Number 28, Pathard matter. Lordship, I had submitted my written argument. Lordship had asked about the authority.
Judgment is there, madam.
We could not lay
Madam. What will happen, madam, in the event, madam, the contract is, madam, floated after the, madam, yes, please.
Basically the interpretation of 9-4 that to that effect. The Lordship may pass it.
Madam, to that effect. We have not found anything, no authority to that effect. But, madam, better there, madam, I will also submit one, madam, short written argument.
Lordship may pass the judgment to that effect.
When will you submit the written argument?
Within 7 days, madam. I will, by Monday, I can.
Item 28.
28. Other arguments are complete.
Item 28, heart reserve.
Deeply obliged.
Meet the Lordship. Malad, I have a similar prayer on item 26, Malad.
Hmm.
Here I am waiting for some documents, Malad.
No. We are closing this matter. You get
Malad, yes, Malad, I appreciate that, Malad. But they have raised some, last occasion, Malad, there are some documents, Malad.
You mentioned it when the matter is called up. We'll see about it.
Malad, then an affidavit in the declaration file is that may also be called for, Malad, in the meantime.
Who has filed a reply?
Petitioner, Malad.
You give the speech.
Madam.
Yes.
May I please, Lordship, for listing of a writ petition, Your Lordship, on Monday, Your Lordship.
Why? What is the
Because
subject matter?
The subject matter is the suspension of the principal of the suspension of the principal from the engineering college, Your Lordship. The principal is suspended from his post, Your Lordship, on Monday, Your Lordship, for orders, Your Lordship.
For orders, when was it filed?
It was filed on 12/3, Your Lordship, this year.
Not Monday, come on Wednesday.
Because, Your Lordship, there is Your Lordship, means one more counsel is there. Because Your Lordship, he will appear from Delhi, Your Lordship. On Monday, he will be available.
Monday, we are already filled up. We are therefore asking you to come back on 30.
30.
Hey, please, Lordship, with due concern from the other side, I have mentioned item number 20. Here we are supposed to file one additional affidavit. That affidavit has been sent for vetting. May I pray that the matter be taken up next week?
Item 20.
Item number 20.
Next week, we don't know. 2 weeks. Item 20, at the request of counsel for the respondent, government counsel for the FORA matter step report.
Lordship, in this matter, Lordship, I am paying for a fixed date, Lordship.
It's a fixed date today. You are agreeing to an adjournment. Why should we fix a date for adjournment?
If they are supposed to file the...
You have agreed. If you object, we'll take up the matter.
Any other date would be okay,
No,
Lordship, but
no
kindly-
fixed date. After 2 weeks, you need a fixed date, you make mention again. After 2 weeks. Yes.
For listing of the matter for next week, any day.
Monday.
May I please, Your Lordship? I beg to mention item number 30 up to the list, my lord. I mention on behalf of Mr. DJ Kapil, my lord, who is out of station, my lord.
Matter has been adjourned for so many.
He is out of station, my lord.
You should make it convenient when the matter is listed.
Next week, my lord, any day, my lord.
Next week, after 2 weeks. After 30 at the request made on behalf of counsel for the petitioner, matter stands referred to after 2 weeks.
Highly obliged.
May I please, Lordship, with the consent of the other side, I beg to mention item number 23 and 24.
23 and 24, yes. 23, 24. Any objections? All right. 23, 24. You are for the petitioner. Matter stands deferred to be listed after 3 weeks.
May I please, Your Lordship? I would like to mention for listing of an admission matter. On 9 February, the matter was fixed for 25th February, but matter was not listed.
2nd May.
Highly.
Actually, I beg to mention listing of an IA for implement matter.
IA for?
Implement of the finance department.
Sorry, IA for?
Implement of the finance.
Implement, all right.
Friday matter.
Friday. Not on Friday, you take it on Monday?
Monday, Lordship. Many
More than
cases are
30?
fixed, my Lord.
30. 30th April.
May I please, the Lordship? The Lordship, I beg to mention for listing of the matter concerning deities in the market area. Deities in the market area, Your Lordship, the government had
What in the market area?
deities land in the market area. Your Lordship, we had 2 land properties, but the government had taken for development purposes And they have assurance us that they will return to us after the completion of the development.
This is not pertaining to the present subject matter of the bench. This is service bench. This is perhaps bench 5 or bench 4. You take up with the court master. This is not the proper court for mentioning this matter. Yes, check up with the court master.
May please your lordship, I beg to mention for listing, the matter was fixed for today. If it and a reply already filed, may fix on the 24th. Yes, the matter was fixed today.
24 is not possible.
Transfer matter, I have not received salary also.
On 1st of May. 1st of May.
Finally, 24th,
Is it auspicious on 24th?
His lordship, I have not received a salary. I could not join
For how long? For how long?
in my service.
From how many months or years have you not received your salary?
Last year, 3 months,
3 months. You wait for 1 more week on 1st of May.
lordship.
All right. Yes.
Right, my lord.
Yes.
My lord, I have filed an interlocutory application for my lord, putting an order for granting subsistence allowances. My lord, while I was being arrested as a sub-inspector of police, and on 9/1 I have been arrested on a charge of an 302, my lord. Then I was in judicial custody till my lord.
You are placed under suspension, deemed suspension,
Yes, my lord, deemed substance,
but no
DP
subsistence allowance.
No. DP has started, my lord. And while DP has started, my lord, and I have been dismissal from the service. But in the dismissal orders, my lord, no reason, my lord, from which date I have been dismissed from the service. That is under the 54 FRSI, my lord. It's a mandatory, my lord, to mention. I was arrested on 7/1/2000 and in judicial custody till 5/11/2023, my lord. DP started, my lord, and while I am in judicial custody, my lord, DP started, and DP completed in 4/12/2023.
Before you are released from prison.
My lord,
Custody.
my lord, DP was started.
But 5/8/2024 in the writ petition,
My lord.
there is already an order directing release of subsistence allowance.
My lord, yes, my lord, but they have not paid. That is why I have
Why?
filed an
Your
application.
lordship, we have written to them on last occasion. The Honorable Court inquired as to whether any order under Part 54B was passed while issuing the suspension order, because that could actually lead to payment of subsistence allowance. But so far, I have not received any instructions. So may I pray the matter may be taken up after 1 week to get the instructions, your lordship, as to whether that order under 54B. Otherwise, 54A, once this petition is decided, if it is decided in his favor, then he will get everything.
But he's entitled to the subsistence allowance
Yes,
during
I
the period
understand.
of suspension. Why are you holding on to
I
that?
understand, your lordship. That's why I've written to them on 10/4.
There's
Just prior to the
a
holidays.
specific orders also, my lord,
Just
while
prior
in
to the holidays,
August,
your
my lord.
lordship.
But they are not complying with the orders. There, what is it? There is the order which has been stated, my lord, was like this, my lord.
It was fixed
The-
today on 22nd.
Has
may I
not been
pray
paid. The
from one
aspect
week
shall be
time will
looked
be
into
done.
the Lanark State Council, my lord, and steps are directed to be taken for release of the same. So there is a direction to the Lanark Council, my lord. Government, unless and until the lordship has given direction to the superintendent of police, Dibrugarh, my lord, to release this. So I am entitled to that.
All right, we can close this IA if you want with a direction that
My lord, that is, so far the main petition is concerned, my lord, that your lordship has to be looked into. So I is concerned, my lord, it's only the subsistence allowances, my lord.
all right. Heard. Mr. P. Poral, Learned Senior Counsel, assisted by Ms. A. Bhattacharya. The applicant, Mr. D. Bora, learned advocate appearing for the opposite party, all the opposite parties. Stop. The accompanying writ petition being WPC 3874 of 2024 was filed by the petitioner in good challenge. The putting to challenge the orders passed by the opposite parties against the petitioner, dismissing the petitioner from service, as well as the subsequent order passed by the appellate authority dismissing the statutory appeal filed by the petitioner. Stop. This court, by order dated 5/8/2024, while issuing rule, permitted the respondent counsel to look into the aspect of release of subsistence allowance, and steps were directed to be taken for the release of the same. Stop. It is submitted by the learned senior counsel that notwithstanding said direction issued, the subsistence allowance has not been released.
For which I have approached Milord by 22/8/2024 by annexing the orders before the Superintendent of Police. Milord.
The petitioner has also approached the opposite party authorities on
22/8/2024, that is the page 12, Annexure 2 of my interlocutory application, Milord.
had approached this competent authority, namely Superintendent of Police, Dibrugarh District, by representation dated 22/08/2024, enclosing a copy of the order dated 5/8/2024, passed by this court in WPC number so and so. Stop. However, the subsistence allowance has not yet been released. So, agreed, the present IA has been filed, praying for suitable direction. So, Mr. D. Bora, learned government advocate, submits that his instructions in the matter are not complete. He would like to obtain required instructions in the matter. The present IA is filed for a direction to the respondent authorities for release of the subsistence allowance during the period which the petitioner was kept under suspension, kept under deemed suspension. So, this court, by earlier order dated so and so, had already directed the respondents to look into the matter and pass necessary order. So, in spite of such specific order, the petitioner as an applicant is before the court, praying for appropriate orders as subsistence allowance has not been released. Agreed. The present IA has been filed. So, considering the submissions made and also taking into consideration the earlier order dated so and so, passed by the court in the accompanying writ petition, this court makes it clear. This court considers it appropriate to close the IA at this stage to reiterate the directions already issued by the court by issuing a specific direction to who is to be released,
Superintendent of Police,
MRT.
to the
No,
respondent number
Dibrugarh.
2, the Director General, and more particularly the Superintendent of Police, Dibrugarh, come disciplinary authority, to forthwith release the subsistence allowance payable to the petitioner during the period of his suspension, during the period when he was under suspension. When was he under suspension?
he was on my lord, 8/1/2023. He was put under suspension. Arrested on 7/1/2023. My lord.
From 8/1/2023
My lord.
till
Sorry, 9/9. My lord. You kindly see. Still, my lord.
8 or 9. First, tell us from which
I'm
date
sorry,
you were
well,
suspended.
It was 9 January, my lord. Your
9
lordship, with
January.
page 36, my lord. Page 36, my lord.
Of the
Is the
writ-
order of suspension, my lord.
from the date on which he was placed under suspension by the order dated 9 January 2023 till the time the said suspension order was continued against the writ petition. So this the entitlement of the petitioner shall be worked out as expeditiously shall be worked out as directed here and above, and shall be released as expeditiously as possible within the outer limit of 60 days from the date of release, receipt of a certified copy of this
My
order.
lord.
IA accordingly stands allowed. Hera, since in WPC 3874 rule has already been issued, the matter be listed for hearing.
Obliged, my lord. Yeah, please.
Yeah.
In this case, my lord, some settlement process is going on, my lord, between two wives. In this case, my lord, settlement process is going on, my lord, between two wives regarding pension and pensionary benefit. So I pay for
It is submitted by the council of the bar that an attempt has been made by the parties for out of court settlement of the grievances. Accordingly, the council jointly pray for 4 weeks' time.
on 7 May, lord, if not
2 weeks' time. Matter be listed after 2 weeks on a date to be fixed by the respondent. You make a mention if required.
Lord.
We are giving you 2 weeks' time. Yeah.
I think
Yes.
As per the last order, we are directed us to file an affidavit, and I had also issued a report that affidavit to be filed. We have filed our affidavit on the 11th of April of 2025, but the same is not on come on record. But
this morning, my learned friend could have mentioned it and get it list.
You should have mentioned it.
my mistake.
Then we'll keep it next week, whatever.
Yeah.
It'll be listed, matter be listed next week.
Not on Monday, any other day. Sir.
Then let it come on
Possibly kindly give a date, Miller.
on 1st of May.
Yes.
1st of May, the affidavit stated to have been filed by the respondent authorities shall be connected to the record by the registry. List accordingly.
may I please your lordship, the respondents have filed their affidavit. We require some time to file our reply.
Reply.
Lordship.
Counsel for the petitioner submits that affidavit in opposition has been filed by the respondent, and they will pray for 2 weeks, 3 weeks,
2 weeks.
2 weeks time to file their reply. Just after 2 weeks.
Much obliged.
Mr. Kolita for
Industries.
industry.
No one.
Mr. Sharma for
Accountant.
accounting.
Total construction of health.
Yes.
Item number 7, देखिए. My lord, I am appearing in item number 7. Gautam
Seven.
Construction.
Yes.
My lord, I have prepared a small list of dates as well as my. এখন দিব নাকি? My lord, if your lordship kindly
This
take
matter
this
was, these matters were hard,
hard at some length.
some leg.
Yes. My lord, our only contention is our activity is exempt. And my lord, exactly.
I'm thinking whether we should hear it now or I should release it from part.
No, lordship.
We are taking up a separate pen.
Lordship will hear it, my lord.
All right.
If not today, if it is
No,
inconvenience.
no, we'll hear it today.
Yes.
Hear it today. Otherwise,
Yes.
because I thought these matters we had already, most of the hearings were closed.
Yes. Well, only in this case, my lord, I could not advance my argument because all coincidentally, my lord, I was busy in some other court. That's why matter got postponed, my lord. Now, what had happened, my lord, this two show cause notices were issued. One on 21/10/2019 and another on 9/1/2020. Now, the show cause notices, if your lordship will kindly come to the writ petition, is at page number 47. And this is for the financial year 2014-15.
Yes.
Now, kindly see, my lord, whereas it appears that Sri Gautam Construction Company holding service tax registration number so and so by business name Sri Gautam Construction and falling within the jurisdiction of the Central Excise and Service Tax, Guwahati have provided taxable service other than those covered in the negative list of services covered under section 66B of the Finance Act, whereas it appears that the SSC has suppressed the actual value of services provided during the financial year 2014-15 and did not fully disclose their liability in their ST3 return for the financial year 2014-15 and have consequently short paid their service tax dues to the tune of rupees 30 crores and odd in violation of censure. This is in substance, my lord, the allegation. Now, if a lordship will kindly come to page number 52, my lord. The notice is required to produce at the time of showing cause all the evidence upon which they intend to rely in support of their defense. They should also indicate in their written reply whether they wish to be heard in person or through their legal representative before the case is adjudicated. If no mention of the same is made in their reply, it shall be presumed that no personal hearing is desired by them and case may be decided on the basis of evidence available on record without affording them any opportunity in the matter. If no cause is shown against the action proposed to be taken against them in the stipulated period as shown above, or if they fail to appear before the adjudicating authority when the case is posted for hearing, the case will be decided ex parte. So, my lord, we submitted our reply. Then, my lord, our reply is at, my lord, page number 89. If your lordship would kindly come to page 92 for a moment. Based on some IT returns, my lord, they have taken this view, which is actually not correct. Please come to para 8. This is our reply. It is a fact that notice filed ST3 return for the year 14-15, disclosing the taxable work carried on by him. The department was aware of the activities carried on by the noticee. Hence, the allegation of the department alleging non-submission of various documents for ascertaining taxability is not tenable in law. Further, the department is aware of the fact that noticee is a registered SSC under the Finance Act for providing taxable services under the category of works contract service. Hence, allegation of willful suppression of fact to the department is not sustainable under Section 73(1) of the Finance Act. That it is pertinent to mention here that the total turnover received of the notice for the year 2014-15 as shown in the audited profit and loss account and balance sheet is 245 odd crore, out of which the taxable turnover is 11 crore 45 lakhs. And the remaining balance amount, that is so and so, is exempted turnover as per the mega exemption notification dated 26/12 as amended. So this is our case, my lord. Since we're undertaking construction for government, at this particular works contract service is exempted. Then my lord will kindly come to page number 96. This is also barred by time. For that the instant show cause notice is not sustainable on the ground of limitations, it is to mention here that the dispute is for the period 2014 to 2015. The present show cause notice has been issued on 21/10/19.
They have reopened it on the ground of suppression.
Yes, there was no suppression, my lord, because these are all exempted.
No,
Their assumption that
you are claiming exemption under what provision?
yes. That notification, my lord, at page number 188. And in respect of my another, my lord, work, they have exempted. Page 188. This is notification dated 28th June 2012. In exercise of the power conferred by subsection 1 of section 93 of the Finance Act, and in supersession of the notification number so and so dated 17th of March 2012, published in the Gazette of India Extraordinary Part so and so, the central government being satisfied that it is necessary in the public interest so to do, hereby exempts the following taxable services from whole of service tax leviable thereon under section 66B of the said act. Now, my lord will kindly come to next page, page 189. 12. Services provided to the government, a local authority or a governmental authority by of construction, erection, commissioning, installation, completion, fitting out, repair, maintenance, renovation or alteration of a civil structure of any other work meant predominantly for use other than commerce, industry or any other business, a historical monument, archaeological site or remains of national importance, etc., a structure meant predominantly for use as educational institution, clinical and art of culture establishment, canal, dam and other irrigation work, pipeline, conduit for plant, etc., water treatment, residential complexes predominantly meant for self-use or etc., etc. So, my lord, the construction work which we undertook, these are all covered by 12, A to E, F.
This is operative from June 2012.
Yes. It was subsequently, my lord, the period is curtailed. That is also there, but we fall within that period.
And the show causes were with regard to which period?
14 and 15. This one is for 14 and 15 and other is for, my lord, 2015 to 2018, 17-18. There are two show cause notices. One is, my lord, 21/10/19 and other is 9/1/2020. That is for the financial year 15-16 to 17-18. That is up to June 2017. The second one. My lord, in the adjudication order, they refers to our contention, but they do not deal with it. Now, my lord, I'll just show one thing. If your lordship should kindly come to page number 199, my lord. This is another adjudication order dated 24/3/22 of the petitioner in joint venture with one Valecha. Now here, my lord, they have exempted the same work, my lord. If your lordships would kindly come to page 204. Para 3.4 towards the bottom. As per clause 13A of the mega exemption notification dated so and so, services provided by your construction, erection, commissioning, installation, completion, fitting out, repair, maintenance, renovation or alteration of or a road, bridge, tunnel or terminal for road transportation for use by general public is exempt from the levy of service tax. Further, PW Highway being a government department undertakes mainly construction and maintenance of projects of government for use by the general public. From the discussions in the above para, it is deduced that services provided by the noticee to PW Highway, Government of Assam, PW Highways, Arunachal Pradesh during 1415 are exempt by virtue of section clause 13A of the mega exemption notices as amended. Therefore, I hold the noticee was not liable to pay service tax in 2014. As such, the entire demand amounting to 4 crore and odd made in the notice is liable to be dropped, and the proposal to recover interest and proposal to impose penalty are also liable to be dropped as demand itself is not sustainable. In respect of the same petitioner, Miller, in respect of another word, now, Miller, I have made categorical affirmance in para 29. At page 30, Miller. I am referring to the sub-para, Miller, at page 30. The said adjudication order dated 24/3/22, which I read just now, pertains to joint venture wherein petitioner number 1 is a co-venturer. Most particularly in the aforesaid proceeding, the same very works contracts were involved, and taking note of exemption notification dated so and so, relief as prayed for in the present petition was granted to the joint venture.
Same work.
Say,
or
not same
similar.
work, but similar work.
So this will be similar work.
Similar. Similar. It is thus evident that in respect of the same issue, two distinct and different view has been taken by the department, which reflects abject arbitrariness of exercise of power. As per CBCIC circular, it is the bounden duty of the adjudicating authority, while analyzing ITR TDS data, to find out whether service income earned by the SSE is attributable to any negative list services specified in section 66D of the Act, or exempt from payment of service tax due to any reason. Admittedly, no such due diligence has been exercised in the present case. Because, my lord, it is an exempted service, therefore, my lord, this CBIC circular says that they must exercise due diligence. In this case, if they would have done, they would not have issued this notice. Assuming they issued the notice under some wrong conception. But then when we submitted our reply, they should have taken note of. If your lordship kindly comes to the impugned adjudication order, where they refer to all these contentions, but they do not, my lord, deal with it. For example, in respect of the first show cause notice, the adjudication order is at page 132, my lord. May I have your lordship's kind attention to page 146? Now, this is the rely, page 146, para 4.1.
Yes.
This is the, my lord, reply, our reply, which they are referring to. The gist of the reply dated 23/21 to the demand cum show cause notice dated 9/1/20 is summarized below. This is, my lord, in respect of this second show cause notice. With regard to the allegation of non-payment of service tax with cess of rupees so and so, as alleged in the instant show cause notice, they stated that they had discharged whole of their admitted service tax liability on various projects on which on due dates with intimation to the department, and has been duly reflected in the ST3 return. And even during investigation also, the noticee discharged their admitted service tax liability voluntarily in the head works contract service which were already reflected earlier in ST3 return, and paid service tax belatedly on payment of appropriate interest thereon. The department has acknowledged deposit of service tax, discharging the service liability in para 12.2 of the show cause notice. So these are referred to Milord. Then Milord will kindly come to the next page. Now there, para 4.1.3, now the adjudicating authority refers to the stand taken in the reply that show cause notice is barred by time. That impugned show cause notice is not sustainable on the ground of limitation, as the said show cause notice dated 9/1/20 has been issued, invoking extended period of time after lapse of the normal period of limitation as provided under section 73(1) of the Finance Act. Well, normal limitation is 30 months. But they can use the extended period only in case of gross suppression of material fact, of fraud, etc. It is to mention here that impugned show cause notice dated 9/1/20 has been issued after lapse of 18 months from the date of commencement of construction. It is further submitted that notice undertook construction of the various civil works under the works contract service, a declared service under clause B of section 66E of the Finance Act pertaining to Government of India as well as Government of Assam and Meghalaya, which are public projects, and public are informed by its official gazette about construction work and ask for submitting tender documents and to participate in the bidding in the public interest. The name of the lowest bidder is selected and work orders are issued. This is regarding the how works were allotted. 4.1.4. Department failed to appreciate the contention of the noticee that works contract service provided by them to the government, local authority or government authorities by way of construction, erection, commissioning, installation, completion, fitting out, repair, etc., for use other than commerce, industry or any other business or profession are exempted by entry 12 of exemption notification. These are all of our contention which are taken note of. Further, the department failed to interpret the new entry in the mega exemption which has been inserted as 12A, allowing exemption of service provided to the government, a local authority or government authority by way of construction, erection, commissioning, completion, fitting, repair, maintenance, renovation or alteration of civil structure or any other original work meant predominantly for use other than commerce, industry or any other business or profession, with effect from 1/3/16 to 31/3/2020. That exemption on works contract services provided to the government, a local authority or government authority was withdrawn with effect from 1/4/15 to 29/2/16 by notification dated so and so. However, the government again restored the exemption with effect from 1/4/15 to 29/2/16, giving benefit of exemption to those service provided who have executed contract prior to 31/3/15 pertaining to government and government of authorities by the Finance Act, which with retrospective effect by section 102 of the Finance Act, which received the assent of the President on 14/5/16. By conjoint reading of para entry 12 and 12A of the mega exemption and section so and so of the Finance Act, it is clear that works contract service provided to a government or local authority or government authority become exempted from payment of service for a period from 1/4/15 to 29/2/16 by virtue of section 102 of the Finance Act. Hence, the whole period during which the noticee had provided works contract service to the government authority in relation to construction is exempted from payment of service tax. The department committed an error in interpreting the law and conditions of the exemption notification dated 26/12. Hence, demand raised in these is not sustainable. So these are all our contention, my lord, which are taken note of. Then, my lord will kindly come to 4.1.5. This is an issue, perhaps lordships will have to give a finding also, my lord, that the demand of 1,72 lakhs raised by the revenue on construction of infrastructure at SSB, wholly by later dated so and so, issued by NBCCL, This is National Building Construction Company Limited, involving a contract value of 36 and odd crore, was accepted and executed on 11th of February 2015, being the lowest bidder by NBCC. Bank guarantee of 5% of the amount of rupees 1.so crore. A white bank guarantee dated 25 to 15 was issued by ICICI Bank, Fancy Bazaar, in compliance of the conditions of the contract. It is worthwhile to mention that as per LOA dated 11 to 15, the noticee has to comply with all conditions of the agreement immediately, execution of bank guarantee immediately, and to sign the agreement within 45 days of acceptance of the letter of award, only to complete the formality. It is to mention here that the agreement was entered into after acceptance of the letter of acceptance on 11 to 15. The bank guarantee dated 25 to 15 was accepted by the client, which becomes a complete contract on 11 to 15, and signing of document of agreement is a mere formality. Under the circumstances, the aforesaid works contract is an exempted works contract in terms of NP 25A of this one. So, here I would like to explain one thing. As regards the other transactions, there is no dispute. Now, in respect of the construction, which the petitioner undertook for SSB, that was the agency was National Building Construction Company Limited. Now, in terms of this amended notification, this for a period that is from 1/4/15 to 29 to 16, this exemption was not there, which was subsequently restored. Now, ultimately, it said that, if the contract is executed prior to 31/3/2015, then the benefit of the exemption would be available. Am I clear, Now, in this case, what had happened, this particular work order was issued on 11/2/15. And, we paid the bank guarantee, performance guarantee on 25/2/15. Everything was completed before 31/3/15. Only, the agreement was executed beyond 31/3/15 because there was a window of 45 days. Now, therefore, what we submit is, therefore, it is also falls within that exempted period. As regards other works, there is no dispute. Regarding this work, this is the only point which is to be considered. Whether issuance of LOA and furnishing of bank guarantee, performance guarantee would not lead to a existence of a valid.
When was the LOA issued?
11/2/15. And bank guarantee we furnished on 25/2/15. And it was to be done before 31/3/15. Otherwise, it's an open and shut case, but for this point. Now, after recording all these things, they kindly see, come to the operative portion of the order. They must give reasons why they're rejecting it. Therefore, I was submitting, it's a fit case which should be remanded back to the authority. Page 178, 10.0. First, I undertake to analyze the issue of service tax demand from noticee-wide show cause notice dated so and so, wherein 3.77 odd crore was demanded, alleging that the noticee was engaged in providing taxable service under the Finance Act, and on the discount they had collected, received taxable amount as referred to in para 2(0) herein above, but they did not discharge the tax properly. In this regard, I have examined the document, that is Service Tax Registration Certificate, Work Order, Form 26 AS, Audited Balance Sheet with Profit and Loss Account, etc. Details of the project relating to exempted and non-exempted contract, period of ST3 return with a list of contract on his service tax were paid by them, along with the service tax calculation sheet for the contract service for the year so and so. to June 2017 and payment challenge for the financial year so and so. From the aforesaid document, it transpires that noticee actually had provided both taxable and exempted services during the relevant period. The argument advanced by the noticee has been reconciled with the document as well as several decisions by paragraph so and so and relevant provisions of law as referred to in para 9 herein above has been analytically thought through and following findings are arrived at. From the sales ledger, profit and loss account, etc., I find that during 2015-16 to 20 up to June, the noticee has executed work of Messrs. Rang, Messrs. PGI Sales, so and so, so and so, so and so. On his noticee, received the amount collectively worth so and so, as detailed in so and so, with regard to service tax, together with cess liability amounting to so and so, on the taxable value of so and so, with applicable abatement as per statute was payable under the category of works contract service, or service in terms of 65B 51 of the Finance Act as detailed in table 3. I find that no plea has been put forward by the notice in the defense reply. From the facts and documentary evidence stated above, I am convinced to hold that the service, including cess amounting to so and so, is recoverable. My lord, regarding HPL, PGICL, these are all HCSL. Private. My lord, these are all Government of India undertakings. As regards the notice's claim that an amount of 28 as referred to in para so and so is derived from National Building Construction Limited in relation to construction infrastructure at 32 Battalion Headquarters Howli under letter of acceptance dated which is exempted from service by entry 12A of the mega notification on the ground that the contract which has been entered into prior to 1st of March and the contract has been completed when the offer of service provided that is notice is duly accepted as is evident from the LOA dated 11/2/15 and bank guarantee dated 25/2/15. It has been carefully examined. On perusal of this said LOA, I have seen that the total contract value is inclusive of all statutory taxes, dues, etc., except service tax, which shall be reimbursed as per the stipulation of the contract, and notice has to execute a formal contract agreement NBCCL within 45 days. Further, on going to the spirit of the notification dated 26/12 as amended, it has been provided that exemption of tax and the said work is available if the agreement is entered before 1st of March and on which appropriate stamp duty were applicable had been paid prior to such date. Since letter of award cannot be treated as a, now this is the parameter, since the letter of award cannot be treated as a contract agreement, formal contract or a contract agreement, and notice he has not provided any other details, it transpires that the said service cannot be treated as exempted and hence service tax is paid. However, only ground on which, my lord, the benefit has been denied to us is on the ground that the eventual contract agreement was not signed before 1st of March, this stipulated date. To that our contention is, my lord, that work order is dated 11/2 and the moment, my lord, I give my performance guarantee, my part is over. Ideally, it should the same day the agreement should have been executed. And there was a window of 45 days. That's why I said, my lord, this is the only point where your lordships will have to give a decision bill. Whether on the issuance of a LOA and furnishing of performance guarantee.
That will depend on the NIT condition.
Yes, correct.
What does it say?
Exactly. Normally, my lord, as we understand, the moment performance guarantee is given, my obligation is over.
No.
No, lordship is correct.
LOA is the decision and
Award the contract.
Award the contract. But then
That means there is a requirement on my part, my lord.
Right,
I also have to pay my performance guarantee.
Correct, but that will be relevant. maybe mobilization advances or whatever is to be given so
Correct.
that you can bring the machinery. All these things come into play. Yes, in principle,
So,
you are
so
the short
that means, my lord, that
contract.
means it is a case to be decided on the facts of each case, depending on the contract clause, which has admittedly been not done. So
No,
this is,
but this is a question of rendering service.
my lord,
This is a question of rendering service.
yes. No, my
So,
lord,
whether with
correct.
effect from the date the LOA is issued,
Yes.
can it be said that you have rendered service?
No, no, no. What I say, my lord, it's a question of I must pay my performance guarantee. Then only I can say that my obligation is over. Under the Contract Act, my lord, the moment I furnish my performance guarantee, that means I have accepted the offer. So there was an offer in the form of an LOA. I have accepted the offer by furnishing the bank guarantee. So there is an offer and acceptance. So there is an agreement. There is a consideration. Now, whether, my lord, execution of agreement alone will give legitimacy to the agreement or by acceptance of the contract. And at end of the day, these are all beneficial provisions. And because we are doing this service from some public interest, therefore,
Where is that particular clause? This is 12, clause 12
yes,
of
it
the
is there.
notification.
Yes, yes. Please come to page 149. It's quoted.
So we had just seen that notification of it.
No, that is at Melod. That was the first one. We are concerned with the second one,
12A.
which is at page 149. One I have referred to is the first one, Milord.
All right.
This is the subsequent one, which is relevant.
Yes.
Somewhere in the middle, Milord, notification dated 26/12. Service provided to government, a local authority or a government authority by way of construction, erection, commissioning, installation, completion, fitting out, repair, maintenance, renovation, alteration. Or a civil structure or any other original work meant predominantly for use other than for commerce, industry, or any other business or profession. A structure meant predominantly for use as an educational, clinical, or an cultural establishment. Residential complex predominantly meant for self-use or the use of their employee or other person specified in explanation to clause 44 of section 65B of the said act. Under a contract which had been entered into prior to 1st of March 2015 and on which appropriate stamp duty where applicable have been paid prior to such date. This is the clause.
This is a part of what? The order, impugned order.
Yes, this is a part of the impugned order where this is extracted. This notification dated 26/12 is extracted. Now kindly come to the finding of the adjudicating authority. From the above reference on the conditions of exemption, it is clear that the contract has been complete when the offer of service provider, that is notice, is duly accepted and becomes complete on 11/2/15.
So this is a part of your argument.
Yes.
Written argument.
Written argument.
Reply.
Yes. From the aforesaid work order, there arises a clear acceptance of offer placed by the noticee. It is a settled law that a concluded contract is arrived at only when offer made by one of the contracted party is accepted by the other.
And what is the finding in this
Yes.
aspect?
Now, my lord, regarding the finding,
No, on
now
this.
even we refer to some decision of the
Ah.
Supreme Court also, my lord, at page 150.
Yes.
The law has been settled by the apex code in so and so. Contract is a bilateral transaction between two or more than two parties. Every contract has to pass through several stages, beginning with the stage of negotiation, during which the parties discuss and negotiate, and also consideration, resulting finally in acceptance of the proposal. The proposal, when accepted, give rise to an agreement. The Supreme Court also says that our acceptance is the moment we pay the performance guarantee. Now, from the interpretation of Section 2H of the Indian Contract Act by the Apex Court in the present case, when proposal is accepted by the other party to the contract, it becomes an agreement. In the present case in hand, the valid agreement came into existence on 11/2/2015. So these are all our contentions, my lord. Now please come to me, lord, page 178. I have already read it, my lord. If your lordship would kindly come to page 179.
Yes. Yes.
I have to read from Milord page 178, otherwise the sentence will not be completed.
Please.
Fourth line, notification dated 26/12 on the ground that the contract which had been entered into prior to 1st of March 2015 and the contract has been complete when the offer of service provider, that is notice, is duly accepted as evident from the LOA dated so and so and the bank guarantee dated 25/2/15, it has been carefully examined. On perusal of the said LOA, I have seen that the total contract value is inclusive of all statutory taxes, levies, duties, etc., except for service tax, which shall be reimbursed as per the stipulation of the contract, and the noticee has to execute a final contract agreement with NBCCL within 45 days. Further on, going through the spirit of notification as amended, it has been provided that exemption of service tax on the said work is available if the agreement is entered before 1st of March 15 and on which appropriate stamp duty where applicable have been paid prior to said date. Since letter of award cannot be treated as a formal contract and contract agreement and the notice has not provided any other detail, it transpires that the said service cannot be treated as exempted service and hence the service tax is payable on the execution of the aforesaid state contract. So this is the finding. According to the adjudicating authority, my lord, it is only on execution of an agreement that a contract would emerge. Whereas the Supreme Court says, my lord, the moment, my lord, agreement only contains the terms and conditions under which the parties would abide by. But the contract comes to an existence the moment the offer is accepted. It's something like, my lord, whether a particular firm is registered or not. If it is registered, certain benefits ensue. If it is not registered, certain disqualifications are there. But to say that that partnership cannot enforce is not correct.
Yes.
So, my lord, in substance, this is the case. Now, if your lordship kindly comes to the written submission which I have given, my lord, I'll just read out 2 paragraphs and detail everything, my lord. Please come to page 4, my lord. At just 2 pages I'll read out, then everything will be clear. That prior to the passing of the order in original by the principal commissioner, which has been impugned in the writ petition, 2 so-called notices were issued. One so-called notice is dated so and so in respect of the financial year so and so. Another notice is dated so and so in respect of the financial year so and so up to June 2017. The basic allegation in the so-called notices are that of alleged suppression of actual value of service during the financial year indicated in the so-called notice. The further allegation in the so-called notice.
Just 1 minute, sorry.
Yes.
There are too many written arguments here. So
Sorry, my lord.
which one?
The one I have
this
given
one?
today, my lord, this morning.
This one?
Yes, yes.
Right.
Page 4, and that's why I made it very simple, my lord.
Page 4.
4.
Sorry,
Now I
please carry.
have referred to the two show cause notices in para 1. Please come to para 2.
Yes.
The basic allegation in these show cause notices are that of alleged suppression and of actual value of service during financial year indicated in the show cause notices.
Yes.
The further allegation in the show cause notices is about non-disclosure of service tax liability by the petitioners in their ST3 return. Pursuant to the show cause notices dated 21/10/19 and 9/1/2020, the petitioners filed replies on 23/1/21 and 19/2/21 respectively. The basic projection in the replies filed by the petitioner is that the activity service undertaken by the petitioner during the relevant period did not fall under the purview of service tax regime, the same being exempted by mega exemption notification dated so and so. From the impugned adjudication order, it will be noticed that the adjudicating authority referred to the contention of the petitioners in para 4.1 to 4.1.26 at para 146 to 161 of the writ petition, wherein replies submitted by the petitioners in respect of the show cause notices dated were dealt with. Similarly, from paragraph 4.2 to 5.0 at pages so and so, the adjudicating authority dealt with contention of the petitioners with regard to allegation included in show cause notice dated so and so. This page will be 178 to 187. That it can be gathered that principal stand taken by the petitioners with respect to the impugned demand was that the service undertaken by the petitioner are exempted from the purview of the service tax regime in terms of the mega exemption notification dated so and so. It will be further noticed from the impugned adjudication order dated so and so that while deciding the issue, adjudicating authority majorly failed to take note of the contention advanced by the petitioners with reference to the aforesaid mega exemption dated so and so, and hence the impugned adjudication order is not tenable. It is evident that contention raised by the petitioners were not dealt with and thus prejudicing the petitioner. Under the circumstances, it is respectfully prayed that the adjudication order is not sustainable and hence the same is liable to be interfered with, and the matter be remanded to the adjudicating authority for fresh consideration after taking into consideration the stand of the writ petitioner for the show cause notice stated so and so. The show cause notice are also barred by time. The disputed period is from April 14 to so and so, and the show cause notice was issued on so and so, that is after lapse of 4 years, 6 months, and 21 days from the relevant date, that is 30 months, as specified by section 73(1) of the Finance Act. The other notice is for the period so and so up to so and so. Alert the relevant provision of the Finance Act. Finally, come to section 73. Recovery of service tax not paid, not levied, not paid, or short levied, or short paid, or erroneously refunded. Where any service tax has not been levied or paid,
Now,
or
this is that suppression.
Ah.
Only when there is suppression.
only when there is suppression, fraud, collusion, willful statement, suppression. So is it a case, my lord, where they could have extended the, invoked the extended limitation? My lord, they have taken the figures from the ST3 return.
Their stand is that it is either willful misstatement or suppression. Therefore, beyond 30 days.
Yes, beyond 30 months.
30 months. So
Well, our case is, we say, my lord, the expression, be it willful misstatement, fraud, collusion, it implies something more than mere omission. Now here we say our stand is, because our works contract service is exempted by a particular notification of the government, therefore we are not liable. Now what they did, my lord, they took note of the return which is submitted before the income tax authority, where naturally, my lord, this turnover was more. Will it amount to suppression? There has to be something drastically wrong. It is more than an omission per se. If our
There
stand
must
is,
be a deliberate attempt.
yes, if our stand is acceptable to your lordship, then there can be no question of separation, no question of collusion, no question of willful misstatement. In which case you cannot invoke this extended period. What is separation, my lord? I deliberately, my lord, withhold my income.
So if we hold that it is beyond limitation,
Yes, end of the matter.
further deliberation
Yes.
is not required.
Yes,
Only if we say that, no,
yes.
or
Yes, in that case only a question of remand may come because there is no proper application of. And then I can appreciate that supposing my turnover is 500 crore, I have shown only 400 crore, 100 crore I have not
are
disclosed.
you
That is a different
relying on
issue.
any authority support? Any
On
authority?
limitation. My lord, kindly give me at tomorrow 10:30 I'll give the case law. I thought it's a open and shut case, therefore I didn't brought any.
No,
Anyway,
because
I'll get one or two decisions.
something will have to be referred here to
Yes,
say that
yes.
in the facts of your case,
Yes,
to decide whether
I'll give the decision tomorrow 10:30.
or day after, whatever is
Okay,
convenient.
day after.
Day after. Yes.
That is my humble submission.
I'll have a detailed submission.
First you make your oral submissions, then you support it by written argument. Then day after tomorrow.
And day after tomorrow I'll give this up. Judgment. Recently I have not done, but when I was doing those central excise cases, there are quite a few cases on
The same
same principle, and same wordings.
I think those same judgments with subsequently being relied
Yes.
or referred to. Or like,
Deeply.
yes. Day after tomorrow. For further hearing. Yes.
Lordship, on behalf of DSRF, I am representing item number 15 and 18. And in item number 18, we have submitted written submission today.
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 Item
18.
Okay.
In item number 15, written submission already on the last date was submitted.
Already submitted. Yes.
Item number 8 is not different from the series, my lord.
Item number
8, my lord.
8.
It means segregated, my lord.
What is item 8?
Here, my lord, they have levied tax, my lord, beyond the consideration received, my lord.
You have?
Beyond the consideration received, my lord.
Yeah, what do you say, item 8? You find out, inform the court on 8th, day after tomorrow.
My lord.
Day after tomorrow, you inform the court what is the status. And in the matters where the written arguments have been filed, are you filing any written argument?
File. All that.
All right.
The interim order is there, my lord.
Whatever is there will continue.
Deeply.
Yes. Day after tomorrow. ठीक है argument definitely will part.
May I please it?
Both parties.
May I please it? My lord, matter relate to my non-payment of salary. My lord, initially petitioner, he was appointed in the GMCH, my lord, on 28/1/2009.
Yes.
Thereafter, while his service was continuing, my lord, salary was stopped from March 2016. My lord, the lordship kindly see before my lord going to the merit, my lord. My lord, your lordship kindly peruse the order, my lord, passed by this honorable court on 20/2/2023. There was a specific direction. Attendance register should be produced before this honorable court for verification whether he was in service or not. Order dated 20/2/2023. My lord,
Yes,
Okay, then the
Last
matter
parameter.
is taken up after some time.
get the registrar. Get the registrar. Who's appearing?
Due comment.
All right, after some time we'll follow.
This matter has been fixed for final disposal.
Hmm.
Matter is relating to the promotion to the post of tourism development officer.
Post of
Tourism development officer.
was it heard by this court?
Was not.
Yes.
Lordship, my petitioner, she was appointed by the order dated 31/12/2011, annexure 2, page 38. Your Lordship.
No, first let us understand what is the grievance here.
Grievance is, my lord, my promotion to the post of tourism development officer is due, your lordship.
Hmm.
I was appointed by the authorities of BTC into the assistant tourism development officer, and my next promotion is due to the post of tourism development officer. The BTC do not have the power to appoint a grade 2 post because approval of APSC is required. So, Lordship, since they have, the government of Assam is prepared on gradation list for the post of tourism development officer, where draft gradation list they have prepared, wherein my name has been left out. I preferred a writ petition, which is also before this honorable court, W568/2022, seeking grievance that my name should have been in the draft gradation. I don't say I should be considered for promotion, but my name should be incorporated in the draft gradation list. But your lordship, while the matter is so situated, they prepared a final gradation list, depriving me. They have, lordship, my name was not found in the final gradation list also. So in the second writ petition, which is before this honorable court, writ petition number 659/2024, lordship, I have challenged it final gradation list, and there's interim order operating as of now, my lord.
What is the interim order?
Interim order, your lordship, first, it was an earlier writ petition, my lord.
Yeah,
Yes, lordship.
5568.
Yes. One 104, your lordship. Okay. Not this, my lord.
No promoter.
Yes, my lord. 10. May I have a look?
No vacating petition.
My lord?
No one has filed any vacating.
Yes, they have
Yes,
filed.
I have filed.
They filed.
Yes, they have filed. And matter
The
was.
last occasion it was likely to be heard, but the honorable
Oh,
court
my
said,
goodness.
my lord,
How
finally.
many posts of promoter? How many posts of what is the tourism? What is the post? Tourism of
Tourism development officer.
tourism development? How many posts are there?
Post
I say there is a post in BTC,
One post.
in
No,
BTC
no, no.
area. And there are vacant
26,
posts.
my lord.
Vacant numbers
50%
of posts
direct.
available in the state of Assam. And the criteria of, is, my lord, merit cum seniority.
No, firstly, you are questioning that your name is not in the gradation.
Yes. They said,
Why is it not in the gradation?
they say that I am from BTC cadre. So state of Assam do not have any authority, your lordship. But my contention is that BTC is within the state of Assam. They just can't throw me out, my lord, from the gradation list. And BTC do not have the power to appoint lordship grade 2 post. Since Tourism Development Office is grade 2 post, wherein the approval of APS is required, your lordship. So state of Assam is the ultimate authority, your lordship, to give me promotion.
Let us see your appointment order first.
My lord, appointment order page 38.
In which writ petition?
It's I have annexed in 659, my lord. 2020.
38.
My lord. Liberty আছে, কিছু না মাথা থেকে।
Yes.
Lordship, in pursuance to the government approval number BTC tourism so and so, and subject to discharge without notice and assigning any reason thereof, Ms. Bhumarani Borgeri of village Pure Rupohi district so and so is hereby appointed as Assistant Tourism Information Officer. It was previously known as Assistant Tourism Information Officer. Thereafter, it was redesignated as Assistant Tourism Development Officer. Temporarily in the office of the director of so and so, in the scale of pay, the expenditure is debitable. Lordship, then thereafter, my lord,
Then your
SIO approval was given to my post at page 39. In inviting a reference to the subject cited above, I have the honor to inform you that the government of Assam has created 7 numbers of temporary posts with the permission of Finance Department and the Tourism Department for Boroland Territorial Council headquarters so and so, cited a reference. All the sanction posts have been filled up by observing all formalities except the post of Tourism Information Officer, and the post is still lying vacant, which is to be filled up by APSC Assam. I would therefore request to kindly move the government to fill up the vacant post of Tourism Information Officer.
You are appointed as Assistant Tourist
Assistant,
Information
my lord.
Officer. Now, pursuant to this, you must have been regularized or
Yes, permanent
regularly-
retention of post was given on 2011-2015, page 42. With reference to the subject cited above, I am directed to convey the approval of the Governor of Assam to accord sanction of permanent retention of the following 5 numbers of different posts under the Tourism Department in Boroland Territorial Council, Kokrajhar, with effect from 1/3/2015 on usual scale of pay and other allowances that admissible under the rule.
then 43 you are confirmed.
My confirmation order, next page, page 42. The service of the following employee of the Office of the Director, City Tourism Department, BTC Kokrajhar, are hereby confirmed in their respective posts shown against each of the employees with immediate effect. My name appears serial number 1, Bhumarani Borgeri, my lord. Then, your lordship, they prepared a draft gradation list, Annexure C, page 45 to 48. Provisional draft gradation list, wherein the name of private respondent's name appeared as serial number 1, and other persons are there who are junior to me, my lord. Only he is senior to me. Then, your lordship,
Where is your name here?
my name didn't find a place, so I filed the previous writ petition, and during the pendency of that writ petition, they prepared the final gradation list. Then there are communication, my lord. Communication, my lord. Lordship, there's a letter, 16/2022, page 49, my lord. There is an objection letter given by me, my lord, against the draft gradation list. With reference to the subject, I have the honor to inform you that the draft gradation list of the Assistant Tourism Information Officer has been published by the office number so and so. However, it has been observed that my name has still not been included in the said list, though the required documentation is requested by letter dated so and so, has been furnished through proper channels so and so. I'd like to reiterate here that I had been serving the post of ATIO since 31 December 2011, and all documents relating to approval by the authority, appointment letter and joining report has been submitted to your directorate in due time, along with request for inclusion in gradation list. Therefore, I'd like to request you kindly to review the draft gradation list as published by so and so number so and so. Then, your lordship, there's a communication from BTC Additional Principal Secretary at page 50. To the Principal Secretary, Tourism Department. With reference to subject cited above, I have the honor to inform you that BTC has appointed one Sri Bhuma Rani Borgeari, height number so and so, as Assistant Tourism Information Officer against vacant post of Government Section Order wide under reference. This has been done through proper selection procedure executed by Central Selection Board on approval of BTC authority. As the incumbent has been rendering her service since 31/12/2011 in the post of ATIO. Now the Director comes CHD Tourism Department BTC, Kokrazar has submitted proposal for promotion of existing Assistant Tourism Information Officer post to Tourism Information Officer post. As the matter is out,
What do the rules say?
Rule doesn't say. Rule doesn't say that
What rules govern your service?
some lordship tourism. Lordship, I have annexed the rule.
You've enclosed. Page
Yes,
number?
Assam Tourist Service rule, my lord.
Page number?
Lordship. Lordship, give me 1 minute.
'65.
Yes, that's the amended rule, my lord.
The amended.
Yes. Lordship, page 63 onwards. 63.
21st June 1995.
Yes, sir. Yes.
So the cadre includes your post.
Yes. Tourism Information Officer, it's 6-2, my lord.
Why is there an asterisk mark here?
Page, my lord.
No, it must have been put by.
Oh, once it was heard by Honorable Justice for K. Goswami. Lordship, 6-2 is the Tourism Information Officer, 50% by direct recruit and 50% by promotion in accordance with Rule 14 and 15 for the cadre of Assistant Tourism Information Officer against 50% of cadre strength. Then, your Lordship, criteria for promotion, Lordship may find it 14-2. 14-2 3A, my lord. Has your Lordship got it, page 64?
14?
14-2 3A, page 64.
Yes.
A member shall be considered for promotion to the cadre of Tourism Information Officer under sub-rule 1 of the rule if he has rendered service in the cadre of Assistant Tourism Information Officer for a minimum period of 5 years on the first day of January of the year of promotion, provided that the governor in appropriate cases may relax the period of service therein before prescribed. Lordship may kindly note years of Lordship minimum period of service is 5 years, wherein I have rendered more than 12 years of service. He has passed such departmental examination or equivalent examination as may be prescribed by government and has successfully undergone such training as may be prescribed by the government of Assam. Then, your Lordship, criteria for promotion.
Yes.
Lordship, page 72.
Page?
72. Lordship may kindly note, page 72, serial number 54. The selection shall be made on the basis of merit cum seniority. Lordship may kindly
Page number 72.
2, my lord.
Serial number?
It would be 54. The selection shall be made on the basis of merit cum seniority.
Yes.
Lordship,
Who is to make the selection? Who is the appointing authority?
for the grade 2 post is the government of Assam, my lord, Director of Tourism.
Where is it provided here?
Appointed. Lordship, appointing authority, page 66. Definition in these rules, unless there is anything repugnant in the subject or context. Appointing authority means the governor of Assam in respect of cadres of additional director tourism, joint director tourism, so and so. The director of tourism Assam in respect of cadre, assistant tourism information officer.
Yeah.
Lordship. Now, Lordship, I challenge the draft gradation list, then interim order operating at page 93 to 95, which is operating as of now, madam. Page 95. In the interim, no promotion process should be initiated. As a Lordship copy. Down below.
Yes.
For filling up the vacant post of tourism information officer from assistant tourism information officer till the next date. And it is operating as of now, your Lordship.
Yeah. Then
Your Lordship, there's a letter after the repetition, order repetition was filed. There's a letter dated 4/12/2023, page 96. It was communicated to the additional senior government advocate, Guwahati High Court, in connection with WPC 5568/2022. With reference to the above, I am directed to place before you the following facts for your perusal and necessary action accordingly. Srimati Bhumarani Borgiari, ATO BTC, was appointed by the Director cum Council Head of Department Tourism BTC by the order number so and so. And the method of recruitment is not similar to that of the ATIO appointed by the Director of Tourism under the Assam Tourism Service Rules 1992. Moreover, Bhumarani Borgiari was appointed as per clause 11 of the Government of OM stated 15 October 2004. As per clause, BTC was empowered to appoint all grade 3 and grade 4 posts under its control in accordance with the rules of appointment followed prescribed, thereby creating a separate cadre. As such, Srimati Bhumarani Borgiari was appointed under the BTC cadre, and hence her controlling authority is Director cum CHT, Tourism Department, BTC, and not Director of Tourism Assam. In view of the above, her claim for inclusion in the state gradation list cannot be considered as the amalgamation of two cadre is not permissible.
which page you're reading now?
Page 96, my lord, Annexure 21. It was communicated by the additional senior government advocate. Then there are chronology of events. Page 97.
Yes. Then
Page 97, your lordship.
97.
Yes, it is a part of the communication dated 4/12/2023. Page 97. Srimati Bhumarani Borgiari by letter number so and so filed a petition objecting to the draft state gradation of ATIO.
What is 97?
Page 97
What is it?
is a chronology of events that is a part of the communication at page 96 of the page 96. Communication dated 4/12/2023.
410 96 does not reflect it has got any enclosure.
No,
96.
but 97 says as enclosed, man.
Yeah, but 96 is the covering letter, isn't it?
Yes.
There's no reference that has enclosed anything. Anyway,
Okay. The views of the tourism department is given at serial number 3, page 97. Bhumarani Borgiari, ATIO BTC, was appointed by the Director cum CHT Tourism Department BTC at order number so and so. As per clause H of the Government Office Memorandum dated Dispur 15/10/2024, BTC shall be competent to make appointment on all posts under its control in accordance with the rules of appointment followed prescribed by the Government of Assam. The council shall constitute a selection board for appointment to be made by it and shall also make rules with the approval of the Government of Assam to regulate appointment. All circular relating to the filling up of vacancies and appointment issued by Government of Assam from time to time shall be followed fully. However, the post where recruitment is to be made on the recommendation of APSC shall not be covered under this provision. So my case is, my lord, since it's a grade 2 post, lordship, recommendation of APSC is required, your lordship. And BTC is not empowered. As per Rule 14, Sub-Rule 1 and 2, Rule 15 of Assam Tourism Service Rule 1992, the recruitment promotion to the post of PIO is done by APSC. Hence, the promotion of Bhumarani Borge does not come under the purview of the directorate. The whole matter is related to BTC policy of the government, and therefore any decision on this matter will raise with the government. In view of the above, Bhumarani Borge ATO BTC was not included in the state gradation list. The views of directorate were forwarded to personnel department for their consideration. Personnel department requested tourism department to examine and formulate a primary review and take up the matter with the welfare of Boroland department along with the primary reviews. Department examined the matter and it was decided that the objection of Bhumarani Borge is not sustainable due to reason mentioned in letter number so and so. So another note sheet is given at page 19, note 13. So department is requested to examine and formulate their primary views on the matter and they have to take the matter in the welfare department along with the primary views. Then they prepared a final gradation list, my lord. Page 99. It was of 1/1/2024, which I had challenged by way of instant repetition. Names of certain persons are included, wherein the name of the client of my learned friend appears as serial number 1.
Yeah.
My name didn't find a place. The rest of the persons are junior to me, my lord. Then there's a communication dated 101, dated, your lordship, 1/1/2024, and actual 23, page 101. It was,
What is the government's stand here?
lordship, that is the stand. Government of Assam do not have the power.
Any affidavits filed by the government?
In the, they have filed.
What is their stand here?
Speaking order. Well, there is a speaking order on the issue matter.
Where is that?
And the speaking order is also under challenge, I think.
Not challenge. Not challenge.
Not challenge. Speaking order was passed. What your lordship will find at page 193, running page, my lord, part of our affidavit. But the issue here is very simple. The petitioner before lordship is in the cadre of BTC cadre. Now, state government is having a separate cadre for the post of Assistant Tourist Information Officer. Now, unless the petitioner says that I am also in the state cadre, there is no question of inclusion of the petitioner's name in the state cadre. Appointment procedure is different. Appointing authority is also different.
Are there any
rules are there?
Segregating both the cadre?
Rules is for the state government. Now BTC, for the BTC, whether they have any separate rules or not, I don't know. But for the state, there is a rules doesn't
belonging appointed.
So rules only talk about officers appointed by the director of tourism. Petitioner is not appointed by the director of tourism.
Appointed by whom?
Appointed by the BTC authority.
Director of State Tourism Department. Same category of.
No, director from BTC, not this director. The rules I have enacted page 169.
Yeah. Anyway, so what does this speaking order say?
Speaking order, you will also find at page 193. Please go to 193. I am reading from 193, 7th of March 2024. Whereas Srimati Bhumarani Borgayari, Assistant Tourist Information Officer, now Assistant Tourism Development Officer, Tourism Department, BTC, Kokrajhar, had submitted a prayer petition to be undersigned in connection with inclusion of her name in the provisional state gradation list of Assistant Tourism Information Officer, now Assistant Tourism Development Officer, published by order number 10, dated 9th of March 2020. Whereas her name was included in the provisional state gradation list of, her name was not included in the provisional state gradation list of Assistant Tourism Information Officer, as she falls under the Assistant Tourist Information Officer cadre of Tourism Department, BTC, Kokrajhar. Whereas her state petition has been forwarded to the Tourism Department, Government of Assam, Administrative Department, seeking necessary instruction regarding the inclusion of her name in the state gradation list of Assistant Tourist Information Officer by office number dated 1st of June 2022. Whereas Tourism Department, Government of Assam, has submitted their views in connection with the inclusion of her name in the state petition list on 27th of February 2024, according to which her name cannot be included in the state petition list as amalgamation of two separate cadres is not permissible. Hence, her name cannot be included in the state petition list of information officer. And with this decision, the petition of Srimati Priyanka, in connection with inclusion of her name in the provisional state petition list of assistant tourism information officer is disposed. This is the only issue, ma'am.
No, but tell us,
My lord.
for the people. Yes. Tell us about PTC.
Lordship, here after the formation of the PTC, state government Lordship sanctioned and concurred for creation of a single post that is in grade 3. And thereafter, Lordship, there is no approval or no sanction of giving another separate cadre. And Lordship, under the rule, the next post is grade 2, and that is maintained by the state government. The PTC has no other.
Essentially, what you are saying is that there is only one cadre.
Yes,
state cadre. Whether you are state or appointed in PTC or in the state, belong to one.
Yeah.
Any affidavit filing?
Lordship, affidavit we have not, but that is just there.
No, your stand is that for saying that you are not saying that there are two different cadres. You are also not saying that they are one and the same cadre. You are saying that the for existence of no further sector post is available there that
Yes, under the rules, there is no segregation of two.
No, but whether there are separate cadres or it is one cadre.
The rules doesn't provide for cadre.
Exactly. But whether the PTC has decided to create a new come page number 38. The page 38 is the appointing order. First, it is issued by the director come CHD. What is CHD?
Chief head of department.
Chief head of department. So he is a director.
Of district council.
So now the question is, how many directors were there in BTC in 2011? I'm sorry, in the tourism department. In the state cadre, there has to be one post for a director. Now, is the director in BTC equivalent to the director in state cadre, or is it a different post?
Different. Lordship, that for the rules, whether the status is same or not, that I have to take.
You have to show us that at the time when the post of director, whether he was created, whether he was deputed, any separate set of rules were created, or separate cadre was created. You find out the appointment order of this particular gentleman.
Yes, ma'am.
Get us the order. What were the indications there? Give us the relevant materials available in the file at the time if any post as director cum CHD was created. These information are necessary to find out whether there is one cadre or cadre. Prima facie, Mr. Mazumdar, I think there is only one cadre.
No, man, separate cadre. All autonomous councils.
Separate cadre has to be created by the third department.
No, man. So far as the cadre under the state government is concerned, the state government will create. So far as the
That's in theory, that's in principle. But let us take the case of the director cum CHD.
Yes.
One officer of the state cadre cannot go and assume responsibilities in the scheduled area by himself or herself.
No.
There has to be a proper order. Prior to that order, that post has to be created.
Lordship will see page 35, my lord, creation part.
35 of the writ petition.
My lord.
Yes.
His rank will be, my lord, page 35.
Additional director.
It's the additional director. That create another, my lord.
So he is the additional director.
He cannot.
So there is no cadre. It is one cadre.
This whole page 35 is Dr. Kanchi. I am directed to convey the sanction of the government of Assam to the creation of following 7 numbers of temporary posts under the tourism department of PTC. So these creation is for the PTC. Director of Tourism in the rank of additional director. Then,
Yes, but you see, in the usual scale of pay and allowances is applicable under the what rules governing the services of the tourism department.
It is reflected at page
These
56.
are additional posts created for PTC by the department.
Yes.
Under the department. Governed by the state, unless separate are notified.
Page 56 is clear, Your Lord.
That is the issue. Your Lordship will have to decide whether the post sanctioned and created for the purpose of PTC will still be a post under the state government or it will be under the PTC.
It's for you to tell us
yes,
why you want to segregate this post and make it ex-cadre. Essentially, you are saying these are ex-cadre.
Not really, my lord, not ex-cadre. These posts are created for PTC.
No, ex-cadre vis-a-vis the tourism, state tourism cadre. Your that is that the two cadre.
This is the stand we have taken care.
These are created for PTC.
Yes.
Therefore, there cannot be any claim in the state of the state.
That is the
cadre.
that is the.
So to that extent, this becomes ex-cadre. But there is no mention of that in the order creating it.
Page 56, serial number 2, my lord.
Page?
Page 56, serial number 2. Government of Assam, as such, Central Selection Board was instructed to fill up the vacant section post following the service requirement as laid by the Government of Assam Tourism Service. We follow the service rules, my lord, of the tourism department. And the qualification is more than what is required in the Government of Assam. We are more qualified.
Yes, Mr. Mazumdar.
Yes.
Unless you show us by way of some rules or notification that these are only meant to be treated as ex-caterer?
But possibly the question of ex-caterer will not come here. From page 35, the picture is very clear, madam. For these posts are treated for BTC.
Right.
And only for BTC.
That's right, but created by whom? By under what department? Tourism department.
Yes.
There is only one tourism department
The
of the state.
there is one department for the state.
Of the state.
It is under the BTC.
Is under the PTC. There is no separate department of the.
Well, if the lottery goes to the rules panel, the lottery find the state caterer is different.
Rules have not been amended to include this post.
No.
Only redesignation has been.
Redesignation.
No, redesignation, but if nothing is there, they would be excluded. Madam. The rule was made under section under Article 309 of the Constitution.
And my lord, appointment to the post of the feeder caterer, it is to assistant to information officer, is different in the so far as state caterer is concerned. Because lordship goes page 38, my lord, the 1995 rule. Page 67, lord will find the post of assistant to information officer. Page 67.
Yes.
On top, my lord, deputy director, then tourist information officer, then assistant tourist information officer. The post of assistant tourist information officer can be filled up directly, my lord, page 8. And in accordance with rule 8 and sub rule 2 of rule 9 and 18.
You are now in the assistant tourist.
Yes. I have already completed 13 years.
What
of
about the tourism officer information?
That is redesignated as tourism development officer.
All
That is
right.
my next cabinet. Next
All right.
promotion is due, my lord.
That tourism information officer post, which is shown in page number 35,
55.
is that post vacant in BTC?
There is one post and they have advertised it. I have annexed in this one, lordship. Annexure, tentative annual calendar, page 121 to 126, my lord. And according to the instruction received from my client, the one post of BTC is also included.
Vacant.
Yes. But BTC do not have the power, your lordship, to give appointment. Advertisement distance. Page serial number 28, 123. Page 123, tourism
Why
development
do you
officer.
say BTC does not have the power?
Lordship,
It's the grade 2.
Lordship, it's a grade 2 post. And as per Lordship, the memorandum of settlement, BTC do not have the power to give appointment to grade 2 post, wherein the approval of APS is required, your Lordship. Lordship, I have made this statement in my additional affidavit, my lord.
Okay.
It is.
APSC code for tourism.
If your lordship,
Lordship, page 222.
I just verify one thing.
Hmm.
Page 35, your lordship will find.
Hmm.
For the BTC, state government has sanctioned, created and sanctioned 3 pools. I mean, altogether 7, out of which 1 is tourist information officer, to which my land friend is paying for promotion. So in the BTC also, there is a 1 post of tourist information officer. If that be so, my lord, why should a assistant tourist information officer from the BTC again claim promotion in the state cadre? In the BTC cadre, there is 1 post of
That's for the BTC to decide.
yes, my lord, for them to decide and for them to inform your lordship. Let him
If this post is
obtain.
there,
Ah.
but consider the employees were there.
Lordship, I try to get it clarified because all the posts were sanctioned or not.
Yes,
So
that is
whether
the factor.
Of course, it is sanctioned.
Sanction.
It is 35.
Lordship, I will try to get it.
Let him get the.
Before that, my lord, I like to raise one small thing, my lord. I'll not take much time, my lord. Lordship, kindly take up the earlier writ petition, my lord. 5568.
Yes.
5568. Lordship will see. Her grievance is not against me, my lord. She herself stated in her writ petition because I am number 1. Lordship will take up page 13, para 20. Page 13, paragraph 20 of the earlier writ petition 5568.
Page 13.
13. Paragraph 20. May I read, my lord? That the petitioner begs to state they come to know from the reliable sources without publishing the final gradation list. Department of Tourism lying upon trying to appoint persons from the draft gradation list dated so and so in the month of September. In the said gradation list, serial number 2, 3, 4, and 5 will be recently completed 5 years. So Department of Tourism is going to give promotion to them, which will produce the petitioner has been working 11 years in the same establishment, which makes her senior, completed the person serial number 2, 3, 4, 5 of the draft gradation list. Further, the petitioner begs to state that the serial number 2 is the Jagadhara preferred rate appeal so and so. Her grievance is basically after 2 months, and I am number 1. Now, Lordship will take up my IA, my lord, for a moment.
No, you are number 1 in the state cadre.
Yes.
You are not claiming in BTC.
I'm not claiming it.
Now, if her grievances can be redressed in BTC, you cannot have any grievance.
My lord, it is up to the BTC. Even though, my lord, if she comes to the state, she cannot cross before me because her appointment is December and I am February, my lord.
So, therefore, you have filed the
IA. Lordship will take for a moment, my lord. I have clarified all the thing, my lord. Lordship kindly take up 3294 of 24. In that. I don't want.
No, but the question is, how many posts are there available?
Available, my lord, for promotional post.
50%
50% is the direct recruitment.
How many posts? Number.
Number, my lord, only 1 post left on for
Therefore,
promotion.
the interim order has to.
Yes, my lord. That's why, my lord, I pray before your lordship, subject to the outcome of the writ petition, since my promotion is overdue, that your lordship will clarify from my IA. IA lordship kindly take out.
Why do they clarify now when we are hearing the matter?
My lord, lordship will see for a moment, my lord, what is my grievance. As a respondent number 1, private respondent, I am standing serial number 1. And final gradation list
is not seniority come merit.
No, man.
Then it is merit.
Merit comes here, even though, my lord, in the selection list.
Seniority by itself will have no role to play.
No, my lord.
Unless
But
you
serial number, I am the 1. She cannot come above.
That argument is acceptable when promoter is only on the ground of
Seniority comes. But here is the merit
merit
comes.
seniority.
Merit comes.
Junior may also come above.
Yes.
If it is merit come seniority, merit remaining same, senior will come.
Seniority will
Senior.
But first, merit will have to be done.
My.
merit which have been tested
And,
by
and
the
it is not a case that one.
No.
So
But
what is the number of?
merit will be decided by the
No, what is the number of probable candidates? 1:4.
ones.
1:4.
and DPC, all these things DPC will see, my.
So if she is number 2, then also it is included.
She
in
cannot
the-
come number 2 also.
Then?
Lordship will see from her appointment month is more than later than me 11, 12 months. And in the meantime, some other person is
Therefore,
also
we
there.
are trying to see if the BTC can accommodate her.
Oh,
If
yes.
the BTC can
Yes.
accommodate
If it
her.
is BTC, my lord,
Then
the,
the whole matter
all
can
the
be
matter ends up.
Well,
Because
let my learned friend
as-
obtain instruction as to whether the post of tourist information officer, to which post my learned friend for the
she
petition
can
is
be
praying
accommodated
for
there in
petition.
BTC.
Then entire
Yes.
matter can be sorted. Let him obtain.
Yes, all right.
But Lordship, as per office memorandum between the Government of Assam, Government of India, and the BTC, BTC do not have the power to give appointment to grade 2 post.
Let them
No, let him
clarify.
bring start.
Let them
And
clarify.
she, my lord, regularized, my lord, only in 2015.
How much time do you
16.
require?
Lordship, 2 weeks.
But lordship, can it be kept as a part of lordship has heard the matter at land?
Hard.
Jade.
And sir, and
Development Officer,
what was it earlier called?
Tourism Information Officer,
Officer. Subsequently, renominated as officer. The petitioner takes the member of the cadre of the state department and other governing services. He claims he qualified to be considered for next time also. The Kerala state responded, however, and
Timing correct.
that he was appointed under the BTC and therefore not entitled to either no the state under the state from the creation of posts from the order made for creation including the post parent home page. What is that existent? What is the information of it? By order dated 17th February of the time. See that 7 posts existed information created by government or the correlate editor. The 7 put the post of a director of the rank of a director. Now renamed as development and existed including other posts mentioned there. The petitioner the respondent certified after that they will accept or let that unappointed query raised by the court.
I will go.
As whether the post shown in the
But there is a whisper in the bar, my lord. Some email has been received about a threat of bomb implanted in the whole building as well as in the new. And police squad has already come to evacuate.
Has already blasted already.
Already.
It is perhaps the splintered. Who has received that email?
I think I don't know. I'm just told that email is received by the DSP.
Pointed to it. But that will come.
In my additional library, I have taken this and they have advertised the post in the PTC area.
By this time, some person have been
in the post of PTC information wrote it the indicated that like whether the department had considered
in that PTC.
Internet topic that you have made that they are considering the allow prayer concept of good.
Well, the date may be fixed, my lord.
$15th,
My lord. As a part hard matter.
15th May.
Lordship.
Lordship,
As a part
interim
hard
to continue.
In interim order, if any, will continue.
DP
Interim order in 6.5 something, no?
Yes.
659.
5568. 5568 will continue. Actually, 5568 has become infractuous today.
Basically.
In view of the final gradation list, 5568 has become infractuous.
But the issue is same, my lord.
You are challenging the
For inclusion in the
you are challenging your non-inclusion in the draft.
yes, my lord.
Now the final
If
is
the
come.
lordship passes order in the present repetition, I have no.
All right, we are keeping it for 13.
My
Let us,
On that
16.
day, your lordship.
On that day, we'll see.
As a part hard matter.
Why, partner? Why are you
Because
scared?
lordship has heard the matter.
We'll hear it again.
Lordship.
We'll hear
That
it
will
again.
do. That will
Required.
Like.
Okay. Huh? 16. Based on 16. In the matter. Yes. OBC.
Yes. My lord, the brief background of the case is like this. The petitioner is an Assam Revenue Service officer. Now, she was selected to ACS. Sorry, the Assam Revenue Service. Now, my lord, her father is a general caste. Her mother is OBC. Now, she obtained her caste certificate way back in 2009 when she was in class 9 to her parents. Now, my lord, she was married also. My lord, she was married, then her estranged husband in two different stores was troubling her. Eventually, my lord, her caste certificate was recalled or cancelled. Against that, by the state level committee, my lord, against that we preferred a writ petition and the writ petition was allowed. Against the writ petition, my lord, against judgment in writ petition, a writ appeal was preferred. Writ appeal also dismissed. In the meantime, my lord, I was placed under suspension. Then I was not, allowed to join. I moved this honorable court, a learned coordinate bench of this honorable court, my lord, passed an order that I should be reinstated in service. Then, my lord, state did not file any appeal against the first order of the learned single judge, whereby the my lord, the caste certificate was, cancellation of the caste certificate was interfered with. They preferred a writ appeal. My lord, that writ appeal was heard on several occasions. Eventually, my lord, state withdrew the writ appeal. A review petition.
Review against the single judge's order.
Yes, against the division bench's order.
First, there was a single judge's order in your
Whereby, my lord, the decision of the state level scrutiny committee was interfered. Against that, a writ appeal was preferred, not by the state, by the private party. Then, my lord, that writ appeal was also dismissed. Then state filed a review of the writ appeal judge.
Right.
That court wanted to dismiss it, then state eventually withdrew it. Now, my lord, another inquiry has been ordered on the same set of grounds which were subject matter of the writ petition and the writ appeal. And that is what has been stated by this honorable court. That is how the matter is for final hearing.
Yeah.
Now, if a lordship
this court was on the bench of the writ appeal. Page number 93.
no, my lord. No. That is an earlier round of litigation.
Earlier.
And there's nothing to do with this case. That is an earlier round.
Where is the order of the the subsequent writ appeal filed by the
Yes,
state
yes.
was withdrawn?
Subsequently, state file review.
Review, withdraw.
No writ appeal was filed.
And the order of the division bench, my lord, is at page number 147. If your lordship would kindly come to para 4.
Who has preferred this writ appeal?
The complainant before the state level selection committee, my lord, was the respondent in the writ petition.
That was dismissed.
Now, please come to page 158, my lord, the finding of the division bench. This is very important in this case.
Yeah.
In the wake of the discussion made herein above, and keeping in view the categorical epithet filed by the state government authorities before the learned single judge, placing on record the report dated 3/10/19, which was prepared after thorough inquiry conducted by the vigilance officer, that is Inspector of Police CID Assam in the present case, under the supervision of the Superintendent of Police CID Assam, concluding that the allegation regarding falsity of social status certificate of Srimati Monsoon Borkakoti was based on no truth, the only course of action required to be taken as per ratio of the judgment in Kumari Madhuri Patel was to accept the said report of the vigilance officer. For the sake of repetition, it may be mentioned herein that state level scrutiny committee, while passing the impugn speaking order, did not objectively consider to the report of the vigilance officer, that is Inspector of Police CID, which was a mandatory requirement as per the guidelines laid down by Honorable Supreme Court in Madhuri Patil. A perusal of the said speaking order would reveal that scrutiny committee, though referred to the report submitted by the Superintendent of Police, but thereafter no discussion whatsoever was made to the findings of the inspector's report in the speaking order. On the contrary, while coming to the conclusion that respondent writ petitioner was not entitled to the benefit of OBC certificate, the scrutiny committee relied upon a parallel report which got conducted through Circle Officer, Jorat Revenue Circle. Apparently, in terms of the judgment in Kumari Madhuri Patel, the circle officer has no jurisdiction to carry out such inquiry. Furthermore, the finding recorded in the speaking order that mother of Monsoon Borkakoti obtained caste certificate as belonging to OBC in the year is also an extraneous and irrelevant observation, because as has been referred to Supra, in the service record of Srimati Purnima Datta, mother of Kanso, her caste is mentioned as OBC. Testing the report of the vigilance officer, that is inspector of CID, on the touchstone of the principle laid down in the case of Kumari Madhuri Patel, we find that the inquiry report submitted by the inspector CID does not indicate even in the slightest that the particulars given by the candidate were false, or that social status certificate has been fraudulently obtained. Thus, in terms of the first part of the para 13.7 of the guideline formulated in Kumari Madhuri Patel, which provides that in case the report is in favor of the candidate and found to be genuine and true, no further action need be taken. No further action was called for in the present case after detailed and reasoned inquiry, and report had been submitted by the inquiry officer. However, SLSC got another parallel inquiry conducted through Circle Officer Jorat, who apparently has no jurisdiction to carry out such an inquiry as indicated above. Another significant aspect needs to be noticed is that report of the inspector CID, which was submitted after conducting a thorough inquiry in terms of Kumari Madhuri Patil, did not give any indication that the social certificate was obtained by the respondent by providing any false or fraudulent information. Rather concluded that the social status certificate was validly and lawfully obtained. The authorities had no option but to accept the report and reaffirm the social status certificate of the respondent petitioner as per guidelines obtained in paragraph 13.7. Hence, the contrary conclusion drawn by the state level scrutiny committee is absolutely illegal and unwarranted. But that means, my lord, there will be one inquiry after another until such time the state feels that no, there is an inquiry report of mine. In fact, my lord, Supreme Court.
No, then what happened after this?
Now, after this, my lord, after this, now I have joined service because there was an order for reinstatement. Now, my lord, this certificate, so-cause was issued. At page, inquiry was ordered at page 185. On the same three grounds, my lord, which are earlier dealt with in the review petition and appeal. Page 185. This is what we have challenged along with another order. In pursuance to the government OM, a vigilance cell was constituted in the directorate on 6/6/19 memo dated so to deal with matters relating to caste certificate. Member of the cell were director, deputy director, deputy superintendent of police CID, and 2 number of inspectors. As per the above memo, the then superintendent of police CID nominated Satokai Sangsan APS, the then DSP Assam along with Inspector Jadu Malakar and Inspector Dibbajyoti Datta from CID Assam. This is as per so. Sanjeev Hazarika, Deputy Secretary to the Government of Assam, while later dated so to the Director, had requested to inquire the caste status of Monsoon Borkakoti to a committee and submit a report according. Sri Vibhas Chandra Modi, Director, while later dated, had asked Inspector Dibbajyoti Datta to verify the caste certificate of Monsoon Jorat. Inspector Dibbajyoti Datta had submitted his report to the Superintendent of Police of Centro in response to the above mentioned letter received from Director Centro. The detailed report in connection with the matters already been submitted on 17 July 23. The following observations are made.
Here.
In the OBC certificate issued to Monsoon Borkakoti by All Assam Backward Classes Association and countersigned by the then Extra Assistant Commissioner Jorat, the name has been mentioned as Monsoon. Diganta Borua, village headman of Sekoni Dhara, Gaon Jorat East Revenue Circle, under whose jurisdiction Srimati Monsoon Borkakoti currently resides, had provided a copy of the letter he received from Surendranath Bora, the then village headman of Diongia Gaon, Gualgaon, informing that late Shiva Prasad Borkakoti, father of Santanu Borkakoti along with his family, was residing in Diongia, Gualgaon, Moza, Misamora, district Golaghat before 50 and they belonged to Kost community. This Surendranath Bora, the then village headman of Tuenso, denied issuing any such letter, confirming that they belonging to Kost community, thereby contradicting the statement of Digonto Bora. These are all Milord cooked up. My father never Milord said that he belongs to OBC. All along his case is he is general. Because I was born and brought up in my mother's background, Milord, it is in that perspective, Milord, that I was given that certificate. These are all cooked up. All these 3 points I'll show, Milord, were already dealt with in the writ appeal. Monsoon Borkakoti had received a letter dated so from Deputy Commissioner Jorhat, asking her to bring the original document for verification. Later, the aforesaid letter was found to be fake, for which R.A. Karoti IS, the then Deputy Commissioner, submitted a written complaint to the officer in charge for faking her signature and official seal. The following points were not incorporated by EO Debojyoti CID in report dated so. The above mentioned only taken into account evidence. Now, therefore, these are the 3 grounds on which now they would like to reopen the inquiry. First, my Lord, Lordship has already noticed that when a circle officer stopped to make an inquiry, division bench said you cannot do it because you are not the designated authority. Even, my Lord, this additional SP superintendent, he is also not the competent authority. Competent authority is either the deputy superintendent of police or the, my Lord, inspector. Anyway, now regarding these 3 points, my Lord, I'll show these are earlier dealt with. If your Lordship to kindly come to page number 199. There is a limit of harassing people.
Yes.
This is in fact, my Lord, in the writ appeal and the review petition, this was an issue. So I filed an affidavit, my Lord. Please come to page 199, last 2 lines. This was my contention in the review petition. The same point was taken there also. Their ground for reopening the case by way of a review was this. First point states that the name of opposite party has been misspelled as Monsoon Borkakoti, our caste certificate instead of Monsoon. So this is dealt with. Second point speaks about a letter without any specification like that particular, purportedly issued by Surendranath Bora, the erstwhile village headman of Tuenso Gualgaon, district Golaghat, certifying that Shiva Prasad Borkakoti, father of Santanu Borkakoti, along with his family, was residing in the said village before 1950 and they belong to Kost community. However, Surendranath Bora denied issuing any such. As such, CID personnel states that there is a contradiction in the statement of Digonto Borwa, the village headman of Sekoni Dhora, Gaon of Jorhat East Revenue Circle, where opposite part number 1 have been residing since her childhood. Now, without disclosing the statement of Digonto Borwa, a contradiction is sought to be made out. It is no longer a sitting gra that whoever comes to a writ court must come with clean hands. By disclosing the facts in its entirety, telling his petitioner would deserve no consideration. In the instant case, it is seen that only half-baked facts are which are suitable to the review petitioners are sought to be placed for obtaining favorable order. Be that as it may, the opposite party has been residing in her ancestral home of mother at Sekoni Dhora Gaon since her birth. As such, letter of Surendranath Bora Golaghat may not be of any consequence. It seems the said letter has been put up to frame the father of the opposite party number 1 as OBC. But it was never the claim of the opposite party number 1 that her father belongs to OBC. Now the projection they now wants to make, my Lord, that my father wants to take advantage as OBC. I never. He is general. Rather, it has been the persistent stand of the opposite party number 1 that her father belongs to general category and her mother belongs to OBC category. Further, non-disclosure about particulars of the said letter gives reasons to believe that is one of the document which was brought on record by the appellant anti-corruption union in writ appeal number so and so as annexure E calling. This same very document. Hence, particulars of the same are sought to be concealed from this honorable court because such documents were considered and rejected in the absence of any satisfactory answer from the appellant regarding his veracity. Further on such consideration clearly contradicts the claim of the review petitioner that such fact was subsequently discovered since they were party to the writ appeal. Therefore, on this count alone, instant review application is liable to be rejected. Now, third point is very interesting. We'll kindly see how they are trying to twist the fact. The third point mentions about a letter dated so and so, purportedly issued by Deputy Commissioner Jorhat, asking opposite party number 1 to bring the original document for verification. This said letter was subsequently found to be fake, for which Sri R.A. Karoti, IAS, the then Deputy Commissioner, had lodged a complaint dated 3/4/19 before the officer in charge of the Jorhat police station against unknown person for faking his signature and seal. Accordingly, a case has been registered as Jorhat PS case number. Interestingly, CID personnel, for reasons other than bona fide, fails to mention that in this regard, a press release was subsequently issued, whereby it has been clarified that Deputy Commissioner Jorhat has neither any issued letter to opposite party number 1, nor had lodged any FIR against her. Such a press release had to be issued in view of certain news being circulated that said Deputy Commissioner had lodged FIR against OP number 1. Needless to say, that press release was published in Dainik Janambhumi newspaper in its daily edition, dated so and so, as well as other newspaper. If some person having vested interest can fake the seal and signature of the Deputy Commissioner just to harm the opposite party number 1, then such person can go to an extent and fake other document, also like letter of village headman. Nevertheless, the said fact also does not have any bearing in determining the social status of the opposite party number 1, and as such cannot be a ground for review of the impugned judgment. So these were the 3 grounds, my lord, which were pressed into service for review, and review was apparently withdrawn as dismissed. And this was the stand we have taken, and this was the ground taken in the writ appeal also. Now on this they want to start the inquiry again. This is my case, my lord. Can you sit in over the judgment of the writ appellate court, my lord? That order has attained finality. Now the other interim order is, impugned order is at page number 216. 211, Miller. Now, this is by my lord one Moromi Das, inquiry officer, CID. This is the third after division bench order. Now, all the same facts are narrated. Then, if your lordships would kindly come to page number 213.
Yes.
I am reading from the first subpara, Miller. The case was investigated and suspected documents were sent to FSL for examination. After completion of investigation, IO returned the case in final report by Jorhat so and so as true, but no clue involved of accused person, and sent the case diary along with relevant documents to the Honorable Court. During inquiry, it has come to light that Santanu Borkakoti applied for OBC certificate in the month of February 15. Sri Digonto Borua, village headman of Sekoni Dhara village, Gaon, forwarded the application stating that Santanu Borkakoti belongs to post community. Sri Digonto Borua stated that he forwarded on the basis of the certificate purportedly issued by the then village headman of Yongya, Gwalgaon, Dergaon, Gulaghat, Surendranath Bora. The application was rejected as a statement of Kamal Gogoi, President Jorhat District, Other Backward Classes Association, after a complaint received from the Anti-Corruption Union. Anti-Corruption was the person, my lord, who lost, association, who lost the complaint against the petitioner before the state government. During inquiry, Surendranath Bora, the village headman, was examined and he stated that the letter pad and the signature was his, but contents of letter not written by him, and he also stated in writing. During the inquiry, a letter was submitted by Anti-Corruption Union. The letter was addressed to Circle Officer Dergaon Circle from the then village headman of Tuenso, Gulaghat Sri Surendranath Bora. The letter stated that Santanu Borkakoti rented a house in the same village for 3-4 years and landlord belonged to Coast community. It may be assumed that on the basis of being a tenant in Dergaon and also on strength of OBC certificate of his daughter, Monsoon Borkakoti applied for, their daughter Monsoon applied for so and so. But Monsoon Borkakoti got it in 2009. All her she got her certificate in 2009.
Yeah.
There is limit. In another document regarding furnishing RTI reply from Additional Deputy Commissioner Jorhat, addressed to Anti-Corruption Jorhat, submitted so they have ancestral property in their so. During the inquiry, a fake OBC certificate issued in the name of Andonu Borkakoti bearing caste certificate was collected from Anti-Corruption Union Jorhat.
Will continue.
Yes. Oh, sorry.
Yes.
My reply may be taken day after tomorrow.
211. Lord may kindly come to page 213. I read para 13. May I have your lordship's kind attention to para 14. In another document regarding furnishing of RTI reply from Additional Deputy Commissioner Golaghat, addressed to Anti-Corruption Union, Jorhat was submitted. It is stated that Santanu Borkakoti did not have any ancestral property in so and so. During the inquiry, a fake OBC certificate issued in the name of Santanu Borkakoti, bearing caste certificate, was collected from Anti-Corruption Union. Lord, God knows, my lord, why this anti-corruption was the complainant, and the inquiry officer also found in the possession of the, my lord, anti-corruption. As they have manufactured a letter from the deputy commissioner, so it was easy, my lord. And do not know why state has taken cognizance of all these distorted facts. It is assumed that original copy must be in the possession. So everything under the assumption. Then Milord will kindly come to paragraph 16. Purnima Datta was issued OBC certificate. It is okay, Milord, my mother. RTA was filed by a representative of Anti-Corruption Liberation Jorhat, praying for official records of Srimati Monsoon Borkakoti, brother Mrinmoy Borkakoti, etc., etc. Then, my lord, after going through all the documents, records, examining the person concerned, I have come to the conclusion that his mother, my mother, she is an OBC, my lord. After going through all the documents, records, examining the persons concerned, I have come to the conclusion that Monsoon Borkakoti's mother, Purnima Datta, belongs to Coast, which is a recognized. Srimati Monsoon Borkakoti's father belongs to Kolkata. There is no difficulty, yes. Srimati Monsoon Borkakoti used OBC certificate dated 13/11/16 in the name of Monsoon Borkakoti, daughter of Tuenso. There is no difficulty. Srimati Monsoon Borkakoti, Assam Land Revenue Service, under suspension, resided in her maternal home in Jorhat, and by her admission, her parents were living together and have a happy married life. During inquiry, it was well established that Monsoon Borkakoti's parents were never separated nor divorced. Her mother took care of her all along. She did not suffer from any disabilities, socially, economically, and educationally. In fact, they are residing was built 10 years back, which revealed that house was constructed after marriage of her parents and their father was actively involved in construction of house. She stayed at her father's ancestral residence in Silpukuri, Guwahati for her higher studies, which also pertinent to mention that both parents are class 1, not class 2, my lord, class 3. He's a clerk, my lord. Clerk ne kiba taru karo. Clerk. It is pertinent to mention that Santanu Borkakoti have tried to manipulate the inquiry by applying for OBC certificate in the year 2019, for which was not eligible, and also by procuring one false OBC from Golaghat, India 2019. In my opinion, Borkakoti tried dubious method to procure OBC certificate. In 2019, appropriate criminal prosecution may be initiated in this regard. So these are the things. My lord, my certificate is of 2006. Now, this two inquiry has been stayed by this honorable court in this process. Now, my lord, what had happened after these two inquiry were stayed by your lordship? Notice, stay. Oh, sorry. I am told, my lord, there is only notice has been issued. Then, my lord, at page 216, this is another notice which has been put to challenge in this case. Page 216. This is by the beloved Kulosrina director. Whereas Superintendent of Police CID Assam Bhaidi is dated so and so has submitted an inquiry report on the status of your caste certificate as doubtful, which was carried out by inquiry officer Srimati Moromi Das. Whereas in pursuance of directives of the Supreme Court case in so and so, a wide office memorandum has laid down the procedure relating to fake certificate. Therefore, before any action is warranted against you, you are hereby given 2 weeks time from the date of receipt of this so-called notice to explain the reason which led to your obtain a caste certificate to of a caste to which you belong. In case no reply is obtained, necessary action as laid down in the OM shall be initiated. My lords, these two inquiry report and these notices were put to challenge in this writ petition. Yes, my lord, during the pendency of this case, what they did, my lord, if your lordship will kindly have the IA number 2955 of 24. These are only inquiry report we put to challenge, my lord. Now, please come to, my lord, page number 58. Whereas in his meeting held on 25/7/24, had requested director to initiate a de novo inquiry, this office requested Superintendent of Police CID to conduct an inquiry by later dated so in pursuance of the guidelines issued for this purpose. Whereas Superintendent of Police CID by his communication memo dated so has submitted the inquiry report on status of your caste certificate as wrongfully falsely claimed after investigation was carried out by Moromi Das, additional SP. Whereas in pursuance of the directives of the Honorable Supreme Court in so, Government of Assam filed memorandum laid down the procedure for dealing with the matter relating to fake certificate. Therefore, before any action is warranted against you, you are hereby given 2 weeks time from the date of receipt of the show cause notice to explain the reason which led to obtain a certificate of a caste to which you do not belong. In case no reply is received from your end, necessary action as laid down in OM will be initiated. So, my lord, based on those two reports, this notice was issued during the pendency of this case. We put to challenge this order in this IML. Now, please have the order. That will clearly give an entire picture, my lord. Order is a slightly longish order. After hot contest, that order was disposed of. If your lordship would kindly come to that order. Please come to me, Lord. Para 13. However, during currency of the judgment and order dated 1/6/23, passed by the division bench of this court in writ appeal number so and so, a subsequent inquiry was held by CID on 31/7/23 to look into the legality and validity of the earlier inquiry report dated 3/10/19, which had already undergone scrutiny of this court. That is the first report which I placed. In fact, another inquiry on 26/12/23 was also conducted by authorities to look into the veracity of the applicant's caste certificate. This is by the Moromidas. The aforesaid inquiry, that is 31/7/23 and 26/12/23, being in direct conflict with the judgment and order dated 1/6/23 passed by the division bench, the applicant, this honorable court, under Article 226, and by filing petition being so and so, this court on so and so was pleased to issue notice. During the pendency of the aforesaid proceeding, the authorities on 2/9/24 issued a show cause notice to the applicant, wherein the applicant has been intimated that SLSC in its meeting held on 25/7/24 has decided to initiate a de novo inquiry as regards the status of the caste certificate issued to the applicant. Situated thus, the present interlocutory application has been filed, seeking inter alia stay of the operation of said show cause notice. The so and so learned senior counsel submit that pursuant to the single bench and division bench of this court, having held the caste certificate issued to the applicant valid by upholding the inquiry held by the inspector of police, the issue as regards caste certificate has attained finally. He further submits that inquiry report dated 3/10/19 of the inspector of CID was also tested and upheld by the division bench. He further submits that once the issue of caste certificate having attained finality and the inquiry report dated being tested and upheld by division bench, it is not open for the respondent authorities to initiate a de novo inquiry in the present issue. Par contra, Mr. D. Nath Lanet, senior government advocate, submits that inquiry has been necessitated in terms of the legal opinion received in the matter, and he accordingly draws attention of this court to paragraph 4 of the affidavit in opposition in the writ petition. He further submits that de novo of fresh inquiry is permissible in case in hand, as the earlier inquiry into the caste certificate is found to be vitiated by fraud, and the same was issued without any proper inquiry. I have given my prudent consideration to the argument advanced by the learned counsel for the parties and have perused the available materials on record. It appears that the caste certificate issued in favor of the applicant was cancelled by SLEC by the speaking order dated 26/21, which necessitated the petitioner to approach this court in WPC number so. It further appears that during the course of the hearing of the writ petition, State of Assam presented the original records before the court inter alia containing inquiry report dated so conducted under supervision of Superintendent of Police CID with regard to OBC certificate of the applicant petitioner. It further appears that the inquiry was conducted by Inspector of Police, and inquiry report dated 3/10/2019 was submitted, wherein it was found that subject OBC certificate of the applicant is genuine. It further appears that placing reliance on the said report, the learned single judge White order dated affirmed the finding of the inquiry officer in report dated so and so, and set aside the speaking order dated so and so issued by this so and so. Hello, kindly see, this learned additional advocate general appeared in this case, and he considered at this stage, Sri D. Majumdar, learned additional advocate Assam, has produced the record before this court, which contains inquiry report submitted by Superintendent of Police CID with regard to OBC certificate petitioner. The inquiry report is dated so and so made by the Inspector of Police CID. Said report is also reproduced herein below. In inviting a reference to the subject cited above, I beg to state that I have been directed to conduct inquiry on contents incorporated in the complaint letter received from Directorate of Plain Tribes and Backward Classes Assam, enclosing 3 different complaints, one of which was submitted by complainant Biman Hazarika, President All Assam Coast Rajbangshi Union Jorhat, 6 others stating Monsoon Borkakoti, daughter of so-and-so, Ranjit Kumar, ACS Additional Deputy Commissioner Dibrugarh, against Vicky Patel, Superintendent of Police, same Special Vigilance Cell, so-and-so, so-and-so. As entrusted, I visited different locations of the alleged person and found the findings which have been presented below. In respect of Monsoon Borkakoti, I submitted her parental address and parent address, that is Golaghat and Jorhat. In course of inquiry, it is found that father of the alleged, namely Antonu Borkakoti, born and brought up at Silpukuri, Guwahati, followed the original rights of Kolita community and got appointment as medical officer who was posted at Jorhat. The said doctor got married with a lady at Jorhat hailing from Koch community and used to reside in the matrimonial house wherein the alleged Monsoon Borkakoti got birth at her mother's house on 12/4/90, and since then she started her education at Jorhat and accepted the customs of the Koch community. During 2006, while she was student of class 10, she applied for OBC caste certificate on merit of her mother's custom. In fact, that the father of the alleged, though got appointment as MBBS doctor, however, he was not moved for OBC certificate as he was not born in Koch community. And similar. Now they are alleging that he wanted to have, whereas he never did, my lord. And that's why this report is bad according to them, because it is not according to their liking. It is pertinent to mention here that in respect of issuing OBC certificate, Honorable Supreme Court of India passed a verdict in civil appeal number so-and-so, and in connection with the appeal, Supreme Court of India passed judgment that child generally belongs to father's caste. However, the child can claim mother's caste also in certain situation, that if the child is born and brought up, my lord. Yes, their appeal also dismissed. Yes, anti-corruption, the complainant filed appeal. Now, my lord, now kindly come to the appellate portion. No, against this appeal, no, nothing. No appeal. Now, my lord, these two orders are quoted. Now, my lord, kindly see, everything has been done based on the report, opinion of the law officer of the state. Now, what code had to stay, my lord? Now, please come to page 32, my lord, para 33. Now, the two reports which I have shown, my lord, these are based on the report of the law officer of the state, because law officer of the state has expressed displeasure. Para 33. Reading the of this order, my lord. Yes. No. Finding. And secondly, my lord, I'll just rely upon one Supreme Court judgment. Please have the judgment, my lord. Lordship will kindly have this. Yeah, there. You want? Yeah. My lord will kindly come to paragraph 8 of this judgment. Practically, I have booked total. No, I do. J. Chitra versus 2021 9 SCC 811. Fine. Extra copy asked to Amara. My lord, I am not holding that SCC copy. Possibly paragraphs will tally. Please come to para 8. On the scope of, my lord, successive inquiry. In the instant case, has a lordship got it, whether the paragraphs will tally. Sentence starting with in the instant case. Yes. In the instant case, an inquiry was conducted by district level vigilance committee, which has upheld the community certificate in favor of the appellant. The decision of the district level vigilance committee in the year 1999 has not been challenged in any forum. The recognition of the community certificate issued in favor of the appellant by district vigilance committee having become final, the state level scrutiny committee did not have jurisdiction to reopen the matter and remand for fresh consideration by the district level vigilance committee. The guidelines issued by the GO dated 12/9/07 do not permit state level committee to reopen cases which have become final. Now this is important. The purpose of verification of caste certificate by scrutiny committee is to avoid false and bogus claims. Repeated inquiries for verification of caste certificate would be detrimental to the members of the scheduled caste and scheduled tribe. Reopening of inquiry into caste certificates can only be in case they are vitiated by fraud or when they are issued without any proper inquiry. Now, my lord, there was an inquiry. That inquiry was tested by single judge and division bench, and both the courts have. But can you see the language of para 15 of the division bench? Testing the inquiry report in the context of guidelines laid down in Madhuri Pat. The division bench, that means, my lord, these officers, these Moromi Das and these other officers, they are sitting in appeal over the division bench. And my lord, the law officer says, has expressed displeasure for what? My lord, law officer's opinion in legal matters is nothing, my lord. The Supreme Court says opinion of the law officer on a legal matter is not binding. There are Supreme Court judgments. I have brought that judgment also, my lord. itu করতে কালি যাচ্ছে তো 87 আছিল না রিপোর্টে আছে না এআর নাকি এটা দিও না এখানে আছে Please come to para 11, my lord. We have no manner of doubt that the appellants are not bound by concession. No, my lord. No, my lord. Oh, sorry, yes, part of the judgment. Para 11, my lord. We have no manner of doubt that the appellants are bound by the concession made by the learned Advocate General before the learned single judge. It is unfortunate that the state government was not properly advised at the earlier stages of the proceedings in insisting upon the view that such permission was required under Rule 817 and that it was justified in refusing to grant the permission prayed for. Now, this is important. The concession made by the learned Advocate General being on a matter of law is not binding. On a question of fact, if, my lord, a concession is made by the learned Advocate General, then that is binding. But on a question of law, it is not binding. Now, my lord, in the facts of this case, what was required was to appreciate the guidelines laid down by the, my lord, Madhuri Patil. And following Madhuri Patil's guideline, my lord, the certificate was restored by the single judge, which was upheld by the division bench. Now, if you are allowing an inspector of police to again sit in over the division bench, my lord, this is disastrous. Actually, my lord, the inspector of police will decide whether the division bench of the High Court was right or not. It boils down to that, my lord. My lord, it's a simple case. These are all alibis, my lord. That Surendranath Bora gave some certificate. Where have they been able to connect that I have applied and I was denied? There is no record. And my lord, I have all throughout my cases, my father is general. My lord, that Ramesh Bhai's case, Honorable Supreme Court said, may I place that judgment? Why this is permissible? এখন আছে নাকি 2012 PSCC 400 আছে Yes. Milord will kindly come to paragraph 41, paragraph 4, Milord, for the fact. 4. let us come from the very first question, first parameter. Question that once again arises before this court is, what would be the status of a person, one of whose parents belongs to scheduled caste or scheduled tribe, and the other comes from upper caste, or more precisely, does not come from scheduled caste, scheduled tribe, and what would be the entitlement of the person from such parent to the benefit of affirmative action sanctioned by the Constitution. Then please come to para 4 of 5, Miller. The High Court seems to have read the decision in Valsama as laying down the rule that in all cases, regardless of other consideration, offspring of intercaste marriage or a marriage between a tribal or a non-tribal would take his or her father's caste from the father. Milord, in Valsama, the Honorable Supreme Court said, Milord, that irrespective of any other consideration, in case of an intercaste or between a scheduled caste or a scheduled tribe, the child will take the caste of the father. Now please come to para 41. The view expressed in Valsama that in an intercaste marriage or in a marriage between a tribal and a non-tribal, the woman gets transplanted into the family of her husband and takes the husband's caste is clearly not in accord with the view expressed by the Constitution bench in V.V. Giri versus so. That is well nigh impossible to break or even to relax the inflexible and exclusive character of the caste system. So, my lord, now my lord will kindly come to paragraph 54 and 55. In view of the analysis of the earlier decision and the discussion made above, the legal position that seems to emerge is that in an intercaste marriage or a marriage between a tribal and a non-tribal, the determination of caste of offspring is essentially a question of fact to be decided on the basis of the fact adduced in each case. The determination of a caste of a person born in intercaste marriage or a marriage between a tribal and a non-tribal cannot be determined in complete disregard of the attending facts and circumstances. In an intercaste marriage or a marriage between a tribal or a non-tribal, there may be presumption that the child has caste of the father. So normally there will be a presumption, but this presumption can be, my lord, rebutted in the following situation. This presumption may be stronger in case where intercaste marriage or a marriage between tribal and non-tribal, the husband belongs to the forward caste. By no means the presumption is conclusive or irrebuttable, and it is open to the child of such marriage to lead evidence to show that she was brought up by the mother who belonged to the scheduled caste, scheduled tribe. By virtue of being son of forward caste father, he did not have the advantage start in life, but on the contrary, suffered deprivation, indignities, humiliation, handicap like any other member of the community to which his or her mother belonged. Additionally, that he was always treated as a member of the community to which her mother belonged, not only to that community, but by the people outside the community. So, my lord, these are the tests. Even if father belongs to general caste, if this can be established, then there is no bar in, my lord, applying for this. In any case, my lord, I got it in 2006 when I was studying in class 10. I never thought that I'll appear in Assam Land Revenue Services. My estranged husband is doing all these things, my lord. Now, in this case, my lord, all these aspects were taken note of by the inquiry officer. And that inquiry officer's report has been upheld by the single judge and division bench. Thereafter, my lord, one after another, my lord, all these things have been going. And my lord, after the Monomidas's report, my father, who is on deathbed, a criminal case has also been registered. My lord, because the law officer feels that he has given displeasure, therefore something has to be done. So things are moving. So therefore, in my humble submission, my lord, the issue involved in this case In my in my humble submission is my lord final, and I'll just place that Kumari Madhuri Patel's case once, my lord, one paragraph. It will even 94(6) SCP. Now, if you lordship to kindly come to para 13. Now, please come to sub-para 5. Each directorate should constitute a vigilance cell consisting of senior deputy superintendent of police in overall charge and such number of police inspectors to investigate into the social status claims. The inspector would go to the local place of residence and original place from which the candidate hails and usually reside, or in case of migration to the town or city, the place from which he originally hailed from. The vigilance officer should personally verify and collect all the facts of the social status claimed by the candidate or the parent of the guardian as the case. So this is the procedure prescribed, my lord. Now please come to para 6. The Director General, on receipt of report from the vigilance officer, if he found the claim for social status to be not genuine or doubtful or spurious or false or wrongly claimed, the director concerned should issue a show cause notice supplying a copy of the. That is not the case here, therefore, Lordship will. Now, please come to para 7. In case the report is in favor of the candidate and found to be genuine and true, no further action need to be taken, except where the report or the particulars given are pronounced or found to be false or fraudulently obtained, and in the later event, the same procedure as is envisaged in para 6 to be followed. Now, therefore, our concern is, my lord, end of the day, my lord, what is res judicata? What is, my lord, principles analogous to res judicata? These are all based on public policy. A issue once decided and adjudicated upon ought not to be reopened at the mercy and desire of some unscrupulous officers. How much ordeal I will face? One after another proceeding. How many? I have 6, 7 writ proceedings I have to file. My only, fault was I applied for a certificate which was given without any problem in the year 2006. Now a projection is sought to be given as if in 2019, my father, who is in deathbed, wants to apply for it. Who is Surendranath Bora? How am I connecting? And my lord, after retirement, and lordship knows, this post Rajbamsi community in Assam, they came to be recognized only in, my lord, 1993. Lordship would recollect there was a presidential ordinance whereby ST status was sought to be given. And there, I think, for about 3-4 years, that ordinance was there, eventually that left. Otherwise, they're OBC. And in my mother's office record, service record, all throughout it is shown as Milord Post Rajbamsi. So I was born and brought up in Jorhat. And my lord, one more thing will kindly appreciate. In Assam, this creamy layer concept was brought in last year. All throughout, that was also a mistake of the government, my lord. Even the higher echelons in the OBC, they were enjoying the benefit. They have not undone all those. And my lord, after he retired from government service, what will he do with his caste certificate? Father. So my lord, therefore my humble submission is, some forces are working against me, my lord. I don't know who are they. Apparently, there is somebody. That's why, my lord, one after another, I've been subjected to this harassment. Therefore, my humble submission is, my lord, the three notices as well as the order impugned in the IA, my lord, are required to be accepted. And whole issue should be given a quietus. Enough is enough. That is my. Lord, I'm glad. Oh, Lord, I'll in 2 minutes. Lord, but you can keep it for some difficult Lord to accommodate. Or I can just ask her to come back. Take a thank you for that. Yes. Lord. Deep blood. Deep blood.
Can this matter be taken up on Thursday, Lordship? Need some time. Though. Lordship, records were produced, Lordship. Records were produced, Lordship. There were orders also on 23 2023 and Lordship on 27 3 2023, Lordship.
No, my lord.
Lordship, it is there, Lordship.
My lord, only two. No.
Yes, Lordship. This was produced before this court. Yes, Lordship.
No, my lord.
And thereafter, Lordship, the court directed to file an
Only, my
affidavit,
lord,
additional affidavit.
Two records were produced, two registers were produced.
Lordship may see, Lordship, order dated 22 2023.
Last for due, Lordship.
1 second. 22
No.
2023. 20th of February, Lordship. Lordship, on that day, March 21 to September 21 and April. Yes, subsequently, Lordship, on. Yes, subsequently, Lordship, on 27 to 2023, Lordship, the entire records were produced and the court desired, Lordship, that the department shall file an additional affidavit bringing everything on record. Thereafter, Lordship, we have filed our additional affidavit. And Lordship, we have even annexed the attendance, Lordship, in our additional affidavit. And it doesn't tally with the attendance, Lordship, attendance sheet, which they have filed in their affidavit in reply, Lordship. Lordship, at page 70 of my additional affidavit, Lordship. Manjuara Begum. At page 70 of my additional affidavit, it is for the month of January 2022. And Lordship, same month, Lordship, for the same month, they have filed a affidavit in reply. And Lordship, the attendance of that period is at page 49, Lordship. It is the type copy and the next. At page 54, Lordship, is the one. And Lordship, in the order dated 22 2023, Lordship, at the last paragraph, the court directed the petitioner to explain as to the authenticity of this attendance, Lordship, because the court has checked the record, Lordship, on those 2 days.
My lord, I have filed, my lord, reply, my lord. My lord, my submission, my lord. Your lordship kindly see. Record only produced, only 2 register were produced, my lord.
Lordship, page 49 is the
Record was produced, my lord, only 2 register were produced, my lord. My lord, for clarification of the attendance in the petition or in the attendance register, my lord. My lord, your lordship kindly see my petition, my lord. My lord, 2009, my lord. My lord, I was appointed, my lord, as a casual labor, my lord. Casual labor, my lord, in the, may I help you desk in my lord, DMCH. And my lord, while I was serving, my lord, my lord, my salary was held up, my lord. My lord, from March 2016 onward. My lord, their affidavit, my lord, their affidavit shows, my lord, you lordship kindly see page, running page, my lord, page 42, my lord. 42 is their affidavit, my lord. I was not, my lord, terminated, my lord. My lord, only grievance, my lord, my salary has been held up. And for clarification that, my lord, their affidavit, my lord, affidavit in opposition, my lord. Page, my lord, 42, running page 42, my lord. With immediate effect until further order. No, my lord, they are affidavit. They have filed reply. They have filed affidavit in opposition. My lord, 4, my lord. My lord, page 42, my lord. Page 42.
Forget the page.
Paragraph, my lord, 2, my lord. Paragraph 2. May I read, my lord? My lord, that answering the opponent begs to state that the writ petitioner was temporarily appointed on Swan to as casual employee on daily basis with rupees 700 per month in Guwahati TMC Hospital, Assam. However, the writ petitioner was very irregular in duty. He left duty without permission of the concerning authority after putting signature in the attendance register. The writ petitioner was absent since without any prior information of the authority. As such, her pay has been held up for above mentioned period. Further, his reply explanation call for my lord. This is my lord. Explanation was called for my lord. My lord, letter was issued to me. I never received any letter, my lord. I have in reply, my lord, I have clearly mentioned, my lord. My lord, that's why, my lord, in earlier occasion, my lord, this honorable court, my lord, wanted to show the attendance register, whether I was present or not, my lord. No, my lord. Not only 2 register was placed, my lord. Thereafter, not. Register should be placed from as per order, my lord.
2016 to 2020.
2020, my lord.
Lordship 27 to 2023 it was placed.
And my lord, my submission, my lord, in another order, this court directed me 20, my lord. My lord, only for my lord, my lord, there are 2, 3, my lord, candidates was appointed along with me, my lord. My lord, everyone put their signature along with myself, my lord. My lord, 16 to onward, my lord. March 16. Yes, my lord. Earlier part received, my lord. Received, my lord. My lord. March 16, my lord. March. Not received, my lord. Earlier part, my lord, I have no grievance, my lord. My lord, my submission, my lord, three candidates were appointed, my lord, from the initial appointment letter. I, one Mustafizur, and my lord, your lordship kindly see, all the persons put signature in the attendance register. Why they not produce, my lord, attendance register? All, my lord, everything will be clear, my lord. That's why, my lord.
Yes, Lordship. Yes, Lordship. The writ petitioner was absent since 1/11/2015 to 29/2/2016 without any prior information to the authority. As such, her pay was held up for the above mentioned period. Further, her reply to the explanation call is awaited till date as per file record. Yes, Lordship. The date, Lordship. That apart, the writ petitioner was again absent from duties with effect from 16/1/2016 to 11/7/2016 without any information. Yes, Lordship. But that's why, Lordship, since there is a confusion of the dates, Lordship, that's why the records were called for, Lordship. And then subsequently on 20/2/2023, we produced records from March 21 to September 21 and April 22 to February 23. Because, Lordship, in her affidavit in reply, Lordship, thereafter, when we produced the record, Lordship, her affidavit in reply that she has filed, Lordship, to my affidavit in opposition, Lordship, the attendance register did not tally, Lordship. So, Lordship, the last part of that order, Lordship, of 22/2023, the court has directed the petitioner to give an explanation as to the with regards to the authenticity of the attendance register that she has placed, Lordship. And she has stated that she has clicked some mobile photos of those attendants. But, Lordship, those were not there in the record. And then subsequently, Lordship, on 27/2/2023, the entire records were produced. And then, Lordship, the
No, my lord, entire record not produced, my lord.
and
My
Lordship,
humble submission
and
before
then
your lordship,
there was
my
a direction of this court to file an additional affidavit since her name could not be seen. Yes. Yes.
two records.
Yes.
Yes.
Lordship. And then on 27/2/2023, Lordship, we have produced everything, Lordship. The order is there, Lordship. Lordship, there we have got the attendance register which the petitioner has annexed, Lordship, in the affidavit in reply for the month of January 2022. Lordship, in our affidavit, Lordship, additional affidavit, Lordship, it is at page 70, Lordship. And Lordship, it doesn't tally with the attendance register, Lordship, that the petitioner has annexed in her affidavit in reply, Lordship. In my affidavit, Lordship, it is shown as page 49, Lordship.
My lord, in this petition, my lord, page 15, my lord.
Casual employees, Lordship.
Page 15, my lord. My lord, three persons were appointed, my lord. And after filing this petition, my lord, another two were Kushal Kolita and Deepali Nath. They were, my lord, transferred to another unit. And myself, my lord, remain in the may I help you text, my lord. My lord, that's why, my lord, in earlier occasion, this honorable court directed to produce, my lord, entire, my lord, my case is entire on, my lord, attendance register. Whether my name is, my lord, signature was put on the attendance register along with, my lord, Kushal Kolita and Deepali Nath.
Everything is produced, Lord.
If my lord,
attendance register
attendance
that they have-
register, my lord. If in the attendance register my name is not there, I have no case at all.
Lordship, it is not there, Lordship. It is there.
My lord, I have no case at all, my lord. That's why my humble submission, my lord.
Lordship, in this time, Lordship. Highly open. Lordship, those were earlier placed. Lordship, I'll get those registers. For Lordship, March 21 to September 21 and April 22 to February 23. And April, February. Highly open.
My lord, 16 to 20, my lord. That is 11. Highly obliged, my lord. Well, my submission, if there is no name, my lord, I have nothing. I have no case, my lord. Obliged, my lord. Highly obliged.
I'm appearing for the health department.
AG.
Yes, ma'am.
I'm appearing on behalf of respondent to R.K. Talukdar. Yes, ma'am.
My lord, their service was regularized and they had discharged their duties. Now the state, my lord, cannot deny their legitimate salary. A petitioner before a lordship has only prayer for area salary.
Okay. But I'm seeing a little accommodation today, madam. Sir, as Porter is some personal difficulty, my lord. Let this matter come up after Thursday, ma'am. Any date may be fixed, my lord. Absolutely.
Lordship, I am for respondent number 8. R.R. Saitya on behalf of SK. SK. Respondent number 8. 80. Accountant.
Yes, my lord. Lordship extensively heard this matter, my lord. My obliged.